Good morning. Good morning. It's Thursday. It's November 14th. I can't believe how quickly time is flying. And today we are flying EDB Air to Utah. Why are we going to Utah? Well, we need to check back in with everything that's going on with Kouri Richins. If you don't remember this case, do not worry. I will do a quick overview after we roll the intro of this case. There are numerous motions on calendar. Here's the caveat. I have been able to get the first 22, 23 minutes of the hearing, and another network had the last 25 minutes of the hearing, but then we're missing a whole bunch in the middle. I am still trying to get it. If I do, then we can decide if we watch the rest of the hearing later, even though you'll know what happened. However, even though I do not feel great, I went to court via audio access on Tuesday and listened to the entirety of the hearing. So we'll watch what we can, and then I will fill in, what we can't watch. I know that some broadcast that audio access online. The court has some really strict rules about that, and this judge is not super happy with media writ large. So there are times I'm a real big rule follower, and there's times that I am not. The neurodivergence picks when and when, but I would like this court to not be super angry at the media. So I'm going to roll with what I'm comfortable with, and I appreciate that you guys understand that, because the judge and the court has been very clear on audio access, and it's not even full public audio access. You have to be approved and stuff for audio access to the court. Remember when the Superior Court of Los Angeles allowed remote audio access, and then it got broadcast, and then they shut down the entire remote audio access program, shut it down for the whole court, shut it down for the entire Los Angeles Superior Court system? Remember that? I hated that. If we lose remote audio access to courts like Utah, right now, Baker Media does not have the bandwidth to fly everybody all over the country to sit in court like other networks do. I think remote audio access gives parity to media of all sizes, legacy, non-legacy, and it's a benefit from the court that they don't have to offer. And I am maybe hyper aware of that because it benefits me and us so much, because if they don't offer it, then they're like, court's open, come to Utah. Okay, well, that's lovely, but that's not always practical for everyone. So I just wanted to share why I do things the way I do, because this court particularly is mad at everything. Mad at media, mad at the internet, mad at all the things. I also don't want to hop on a plane every 3 weeks or 2 weeks or whatever. So we're going to figure it out. For trial, we are going to have a different setup. So for trial, we will have a different setup, which is tough. So Elise asked, do you have a breakdown for this case? I do. We have a playlist for this case, but I'm going to give a breakdown before we jump in to all of it. So I'm going to roll the intro. Let me know where you're coming in from, what you're drinking. I feel like I haven't asked that in 100 years. I see some of you have gone and got donuts. Some of you have gone and done other things. Fantastic. This is good. This is very full. I made myself a cappuccino. I made myself a cappuccino this morning. So that's what we're doing here. It's good. It is good. I love it. Is it going to clear my sinuses? Probably not. Something will. Don't worry. I've taken the law nerd's advice, and we've got all the things on the way. I've got plenty of water. I'm just going to sound like I sound. It's going to be fine. We're going to go to court. You guys know what I sound like. So I'm going to roll the intro. Then we're going to do a quick summary and what's on the docket for today. And then we're going to go to court. We love this judge. So any amount of court we can get. This morning, as I was talking to Judge Abby and getting ready for stream, I was telling Judge Abby about this judge, and she's just like, so I need a beard. And I'm like, no, the law nerds would stand you as well. The beard is not the only thing, Your Honor. Like, we stand competence above all else, but you can't beat a good voice and then sometimes a beard. But I'm like, no, Judge Abby, we would also stand you. We already do. I said, but what I love, and we were talking about a constitutional issue that he argues later in this hearing. And so we were talking back and forth about that constitutional issue. And she's like, oh, I love the way he resolved that. We had a very lovely conversation. It's fun talking about the judges all over the country. But this judge in Utah, man, I love the way he approaches things. He's firm but kind. He's somewhat no nonsense, but without being gruff. It's just I imagine when they did, because they call people and ask about judges, or at least in California they do. I don't know about other jurisdictions, when people either go through commissions to be appointed for judge or go through commissions to be elected, and they ask about judicial demeanor. I imagine that everyone that was asked about this judge was like 10 out of 10. Like, his judicial demeanor will be absolutely perfect. But we'll see. We'll see what you guys think. Some of you remember this judge. Some of you, welcome. You're going to be delighted. Let's roll it, and then we'll do a summary.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, let's do a summary of this case, because some of you are like, Kouri Richins, I don't remember her. Kouri Richins is the one with the walk the dog letter. So you might remember that she has been accused of poisoning her husband. There is some variance on whether it was a Moscow Mule or not, given the last hearing that we all watched together, the preliminary hearing, and we did cover the entire preliminary hearing. In that preliminary hearing, it was a Moscow Mule, maybe wasn't, but she is accused of poisoning her husband with a 5x like lethal dose of fentanyl. Today, what is on the docket is the state's motion, words that are hard to say, the state's motion to dismiss counts 3 and 4. We'll talk about that. The defendant's motion to reconsider bail, the defendant's motion to expand the jury veneer, though in Utah they say veneer. I literally can't. Veneer, it is veneer. I will always say veneer. What I have found about Latin pronunciations is it very much is regionally specific. Some will say veneer, some will say veneer. I will always say veneer. Veneer sounds like you need an antibiotic. Then there is a defense motion to expand voir dire and jury selection to be in person. And that is stipulated to, but they still needed to argue with the court about it. We'll talk about what that means. Why? Why in the world would you not do in-person voir dire? But in some jurisdictions in Utah, even though we are well beyond 2020, they are still allowing for remote jury voir dire, which means you are questioning the jurors one by one over like Zoom. Oh dear. That's wild to me. It's just wild to me, but we'll see. Then there is a defense motion to sever counts. We'll talk about that. And there is a defense motion to seat 12 jurors. Why? Because in Utah, for non-capital cases, they seat 8. And the defense attorney is like, how can we seat 8? And I was like, girl, go to Florida. They seat 6. Not everybody gets 12. And that is a deeply constitutional argument that the defense knows they're on the back foot on and are preserving that argument for appeal. And they say, we know the law is not in our favor on this, but we are trying to preserve this issue for appeal. So those are that is the swath of motions that we are looking at all together. But let me pull up the indictment first, so that we can talk about what the state is dismissing. I think that'll be helpful. And then we'll talk about some of the other motions so we have a little bit of background on them. Oh, where is the amended information? Give me 1 second to find it. Did I plan on pulling it up? No, I sure didn't. I probably should have, but I absolutely didn't. Let's see. Where is my... this is my expanded information. The new information was T. We went over the whole thing, because the amended information had like all of the all in it. And it was, I thought, fascinating. So that's the original information. They had added counts after they did substantially more investigation. And that's when they added the attempted murder from February 14th. Remember at the preliminary hearing, we heard evidence that on February 14th, the victim, Eric Richins, got incredibly sick from a egg sandwich. And the defense was trying to argue that maybe it's because you didn't eat the egg sandwich fast enough or soon enough, or that, we can't tell that the egg sandwich is connected to him falling ill, etc. So they attempted to argue that the egg sandwich was not necessarily connected to Kouri, even though the evidence seemed to contravene that. And so they were arguing that attempted murder should not be connected here. They're going to argue that again. Where is my second? I am having such a hard time finding my second information, which is so annoying, but I should have pulled it up sooner. That's, Emily, we get what we get and we don't get upset. But it was a very interesting amended charges. I've linked it. I had tried to make it easier for myself and then I made it harder for myself. Okay, so my neurospicy friends, do you ever have the special place that you put things? Or I'm going to do it this way so I won't forget. If I do it this way, then surely I won't forget what I have done. And then you lose literally everything. I'm going to do it this way so I won't forget. And then I'll forget. Passenger shaming. So good to see you. 2 years. Awesome. It's good to see you. We're going to be flying to Utah in just a moment. We won't put our feet on the back of anyone's seat. Cause we know we're law nerds. We know etiquette very. No, Kouri, not you yet. We need to do this information first. So yes, all of you understand. It's I put it there so I could find it easier, and then I couldn't find it. Me, always, and every single time. Me. All right, this is the second amended information. This pertains to two of the things that we're going to be talking about today. The second amended information has the count 1 aggravated murder from March 3rd, 2022. Count 2 is the attempted murder from February 14th, 2022. That was the breakfast sandwich. So Mad X Mickey in the chat said egg sandwich or egg salad sandwich. I approve of both, but this was a breakfast sandwich, like a egg, bacon, bagel sandwich. I love a breakfast sandwich. This was like a breakfast sandwich. Distribution of a controlled substance, count 3, and distribution of a controlled substance, count 4. The state made a motion to drop count 3 and 4. If you watched me cover the preliminary hearing, I was mad at these counts already. I think they're dumb. I don't like them. I don't like these counts at all. Why? I don't think that the law intends distribution to mean she gave it to someone. I don't think the law intends distribution to mean that you've used it to poison someone. When the law intends distribution, they mean that you are selling drugs. Distribution of narcotics means you are distributing narcotics to other people to take for pecuniary gain. I don't know exactly how it's defined in Utah. Did I pull up the law? No, I didn't. But that's what distribution intends. It intends that you are, in fact, distributing it. Now, the person who gave the fentanyl to Kouri, that person could be charged with distribution. But I don't think Kouri procuring narcotics was meant to distribute those narcotics other than using them as essentially a weapon. I don't think that's what the law intends. They're getting rid of count 3 and 4. I thought count 3 and 4 were dumb to begin with. I don't think distribution means you give it to one other person without them knowing. Yes, you can get popped for distribution for selling it just to one other person. Sure, but not for giving it to someone unbeknownst to them. And that's the case here. I don't think the case fits. I don't think it's what the law intended. I think it is a reach, and I think it's correct that they got rid of that count. She was not going to get narcotics from the drug dealer to then sell drugs. That's not what was happening here. She was getting it for the purpose of using it as a weapon. I don't think they can prove anything else. I don't think they can prove she was selling it. I don't think they have any other proof of that. I think that prosecutorial restraint is a necessary thing. And I think overcharging will always turn around and bite you in the ass. So again, I think she was using it as a weapon. So it really is, this really doesn't fit in my mind. So Red Sky asked a very good question. The state is not seeking the death penalty in this case. It is not a capital case. So the state's not seeking the death penalty. So non-capital case. All right. So then the defense has made a motion to sever counts, which means to move them into a separate trial, to separate them from this trial. This happens all the time, by the way, that you can sever counts. This is not uncommon. The state is moving to sever out the mortgage fraud cases. So let me pull all of them up. I'm going to pull up that motion real quick because they're going to go through this pretty fast on the record. And I thought a little background was helpful on the motion to sever counts. So the defense is moving to sever out counts 2 and 4, 2 being the attempted murder, 4 being the distribution that goes to the attempted murder, which is getting dismissed, so that doesn't count. 5, 6, and 9. 5 is mortgage fraud, 6 is mortgage fraud, and 9 is the forgery connected to the mortgage fraud. Oh, and 10, which is another forgery connected to the mortgage fraud. So the defense is asking that the mortgage fraud cases and the passenger shaming. I know you're an OG. You've been here since the beginning. Like back in the Clubhouse days when we got to like voice chat. That was fun. We need to do some of those we need to find a way to do some voice chatting on our members only. So the defense is trying to sever out counts 2 and 4. 4 is gone or will be. 5, 6, 9, and 10. 5 and 6 are mortgage fraud. 9 and 10 are forgeries that go to those mortgage fraud. They are not seeking to get rid of the insurance fraud cases. Those happen after death. The mortgage fraud happened before death, June and August 2021, to the 2022 murder. They argue that these are too far in time and they're only being used really for like the generally bad person. Like, oh, look, she sucks. She's probably a murderer. You can't use it for propensity in that way. So the defense is arguing to pull out those counts, including the attempted murder. I'm not going to give my personal thoughts because I know what the court does because I listened to the whole hearing. So we're going to listen before. It's me, Rachel. Exactly this. It's me, Rachel. The defense is asking to separate these into 2 trials. And when we get into the hearing, we're going to hear about that. So we are going to go to court. This is the first. The motion to sever is the second thing that they hear. The first thing that they hear is the motion to dismiss the distribution charges. So that's the first thing that gets dismissed. The first thing the court does. So yes, the defense is asking for 2 trials and to sever these. After we do the motion to sever, we'll see where we get through and then I will fill in. And then the other video we have is the motion to reconsider bail. So state's motion to dismiss, motion to reconsider bail, motion to expand the veneer, motion for in-person voir dire that's stipulated, motion for 12 jurors, and motion to sever counts. Bail might have been the only one. If you've seen headlines about this case, have any of you seen headlines that are other than the bail motion? Would you have even known that there were, 6 motions? The only headlines I've seen on this are about bail, but there are 6 motions and some of them quite consequential, especially as to the motion to sever. The motion to sever goes to what's going to be shown to the jury. I don't know of anything more consequential than what's going to be shown to the jury. Everything, though, is just like, Kouri Richins wants bail. Well, yeah, of course she does. Of course she wants bail. Of course she wants bail. Of course she does. Her and everybody else. But, yeah. But that's not all that happened today, or Tuesday, as it were. So we're going to go to court. I feel like we should fly there. Law nerds, buckle up. Please make sure your hands and feet are inside the vehicle. Permaneceres sentados, por favor. Emily, that's the Matterhorn. That is not what you say before a flight. Yes, it is. It is what you say before every flight. Very demure. Very mindful. Please make sure all your belongings are stored. And don't be a dick to the person sitting next to you. Let us go. All right, let's go to court. How would we know it's in live court, Emily, if we don't have our little live court bumper on? We wouldn't know. We wouldn't know. All right. Does the monorail also say permanecer sentados? I haven't been on the monorail in forever. The Matterhorn is always, please keep all hands and feet inside. Do they say vehicle still? It's been a really long time since I've been on the Matterhorn. Just Rhonda said, isn't this like her third or fourth bail request? Actually, no. It is, and this is also fair. Just Rhonda, the world is just being operated by meme at the moment. So time is a construct and nothing makes any sense. So it's completely fair. But this is only her second request for bail. They did the original bail hearing that I covered, that we saw. That's where we learned that she literally throat punched her sister-in-law. We covered that bail hearing. Then after the prelim, they said they're going to make a motion for bail, and this is them making the motion for bail now. So I hope that the sound is great. Fingers crossed. Fingers crossed. Pa Tara said, EDB, can they sentence her to death? No. This is a case where the judge will talk about her maximum, but she is facing 2 counts of 25 to life that can stack. So 50 to life, or just life. And we know that Utah does that different than some other jurisdictions in who gets to decide. I think if she's convicted, the judge can only sentence her to 25 to life. And then after 25 years, the parole board gets to decide. I don't think the judge has a whole lot of discretion here. I think the sentence is what the sentence is, and that's it. All right.
Yep. Same for you, Miss Osterla.
Hopefully you can hear court. Please clap if you can.
All right. Counsel.
Louise, she's accused of poisoning her husband. I covered the preliminary hearing. We have a playlist on it. And if you want to zoom back a little, I gave a summary just a few minutes ago.
We're on the record in 231500139, State of Utah versus Kouri.
Everyone now remembers this case. You guys remember this case, right? Now we remember.
Darden Richins.
Hello,
Can I have
Judge M.
counsel for the state make their appearance, please.
Good morning, Your Honor. Brad Bloodworth, Margaret Olson, Fred Burmas.
I also realize it sounds like a potato. I'm going to try to gain it up.
Joseph Hill for the state.
Thank you. And on behalf of Ms. Richins.
Your Honor, Kathy Nestor, Wendy Lewis, and Alex Ramos here with Ms. Richins.
Good morning, Ms. Richins.
I will say this cameraman does swing this camera in the air like he just don't care. So, or they just don't care. The camera person swings it. So if you get at all motiony, I'm just fair heads up. This camera swings. It's like to the left, to the right, to the left, to the right. This camera swings it just by the chandelier. By the chandelier. Yes. I want to swing this camera motion, man. But to the camera person in court, thank you. We are so glad we have footage. I think we are the only ones at this point that have footage at the beginning of the hearing. So my deepest appreciation. However, a slow pan would be lovely. Perhaps.
Okay, we are here
As an
on
aesthetic
several
choice.
motions. I don't have strong feelings about what order to do these in, but I have a proposal if you'll hear me out for a moment. First, the state's motion to
Your Honor, we will hear you out to talk about literally anything. Judge M, we will hear you out on everything.
dismiss counts 3 and 4. Ms. Nestor, any objection?
No objection, Your Honor.
And that is without prejudice, correct, Mr. Bloodworth?
Correct, Your Honor.
Okay. State's motion to dismiss counts 3 and 4, which is docket 703, is granted. Counts 3 and 4.
Do you know what makes me so sad that this judge doesn't love the media? I want this judge to just have a Zoom court. Your Honor, can we just watch you call calendar every day? We'll just come visit your court every single day, Your Honor. We will get a PhD in Utah law just to come hang out in your court every day. Just every day. So what he said is without prejudice, which means counts 3 and 4, if down the road they want to charge Kouri Richins with distribution later, they can. I don't think the facts are the best for distribution. You know that. I said that at prelim, but you can do it. If they want to bring those charges later, they can. But again, if she's convicted to the attempted murder and the murder and gets 50 to life, it's just piling on at that point. Doesn't really matter.
4 and the third amended information are hereby dismissed without prejudice. Ms. Nestor, does it make sense to address the motion to sever next?
Sure, Your Honor.
Yes, Your Honor.
It's defendant's motion to sever, docket 677. Let me ask you just a couple of questions, and then I'm happy to follow you wherever you want to go.
Yeah.
You're asking for an order severing the counts, I think, into 3 trials, potentially, just 2? So trial 1, aggravated murder, and then counts 7, 8, and 11. Insurance fraud in January and June of 2022, and then a related forgery in January of 2022. Is that correct?
Yes, Your Honor.
And then the attempted aggravated murder, would that be tried by itself or with 5, 6, 9, and 10?
Honestly, we hadn't gotten that far. I figure we'll worry about that later.
Fair enough. So the real issue is 1, 7, 8, and 11 by themselves.
Yes.
Figure out what to do with 2, 5, 6, 9, and 10 later.
Yes, sir.
Okay.
3, 6, 7, 5, 809. So what I appreciate about this judge, and when I talk about appreciating his judicial demeanor, in almost everything I've seen him cover, he clarifies the question first and says, okay, just so I'm clear, we're talking about this. I never find him to be condescending. I never find him to be unprepared. He really is very much a, just so we're clear, just so I'm clear, what you want is this and this. And what he's saying in the motion to sever is, I want to make sure that I'm clear on what you want to sever. So these counts, 1, 3's now been dismissed, whatever, these counts go together, and then those counts go together. The defense is trying to sever out the attempted murder from the murder to separate those into 2 separate trials, and then to also pull out those mortgage fraud and forgery cases. Remember, the forgery goes to the mortgage fraud. There's also insurance fraud that was after the death, the mortgage fraud before the death. So they're trying to sever those things out. Lori's like, I now answer to Elizabeth, yes, we just need the judge to be like, get in the car, law nerds. Your Honor, we would die. We would fall off our chairs.
So may it please the court?
Yeah.
It would please the chat if you would pull that microphone a little bit closer, and instead of just letting it go, not, wait, is counsel using a remarkable? She is. Look at that. I spy an e-ink writer. The way I wish that this existed when I was still doing trials in court, the way I wish I had a remarkable back then, I wish. Autumn, yes, I agree. We sure would, but that's exactly what we need right now. I think so too. This judge has no idea. It's like, Your Honor, if there was ever a judge for media court, it's you. You are what the law nerds would pick as a TV judge if we got to pick. I love Judge K. I love Judge A, but I'm sorry, Judge M, it hits different.
The real thrust of this is why to sever the attempted murder charge from the murder charge.
I'm sorry, Your Honor, you can't say thrust this early in the morning. You can't. If you start talking about these motions being girthy, we're all going to lose our minds. We're all going to lose our minds, Your Honor. We're trying to be adults. No, we're not. We're trying to disassociate. Let's be real.
So may it please the court?
Yeah, I mean, the real thrust of this is why to sever the attempted murder charge from the murder charge.
Right. So just to lay a basic foundation, and I know Your Honor's aware, but just for the record. The statute that determines whether counts are properly joined in the information is 77-8A-1, and counts should only be joined if they are based on the same conduct or otherwise connected together in their commission, or if they're alleged to have been part of a common scheme or plan. Now, I did not see the language in this information alleging a common scheme or plan, but even if they make the argument outside the face of the information, it is our position that the first analysis you have to make is it properly joined at all in the information under that statutory analysis? It is our position.
They're talking about the severance and whether or not all the counts are properly joined together and part of a common scheme or plan. Do the mortgage fraud counts properly play into, are they connected enough to the murder and attempted murder? And she's arguing to separate the murder and attempted murder. I think that's a harder argument, but to separate the murder and attempted murder, are they part of a common scheme or plan? And are they connected enough to be brought? Or is it piling on to show propensity, where it's just like, okay, we'll throw everything in and see what sticks, which is why case chat, when you're like, but don't sometimes they throw everything in to see what sticks? Yes, those are RICO cases. RICO cases are like, we can take all this shit and the kitchen sink and put it under the umbrella of RICO and throw it all in. But you generally have to have things well connected, not just in common scheme or plan, but in time. So things can't be so disjointed unless you bring like a conspiracy case or a RICO case, and then you can start to say the common scheme or plan is the organization, and then everything just fits under it. So that's why we're seeing her arguing whether or not these mortgage fraud counts are too far afield from the murder and attempted murder. And in fact, is the attempted murder 2 weeks before the murder part of the same scheme or plan?
That the mortgage fraud, I'll just call them the mortgage fraud counts, do not even meet the statutory analysis. They're just wholly unrelated to the allegations that are made with the allegations of causing the death of Eric Richins.
Let me push you a little bit on that. Just
Okay.
Get your response to what I understand the state's arguments are. The state argues an arc here of conditions prior to June of 2021 in which Ms. Richins had a subjective understanding that she would fare better financially if Eric died during the marriage as opposed to a divorce. And
That is the state's argument.
had a real estate business that was highly leveraged, running out of credit, owed a lot of money to hard money lenders. Starts doing things allegedly in June of 2021 to fraudulently secure more liquidity and credit. And in the state's view, I'm inferring this, I think, didn't want to get found out. And so it would that, and I understand there's a lot of other steps we need to go through here, including 404B and 403, but why wouldn't that create the type of direct relationship or precipitating event relationship that the Utah Court of Appeals talks about when interpreting when things are connected together in their commission?
So the court is asking her, and I know there's a lot of background garble because though Idaho does not record court on potato, this one has a bit of background noise, and I've got it gained up. Though we do have closed captioning, which is 10 out of 10. So he's saying he's posing to the defense the state's argument and asking her to respond to the state's argument. The state is saying that Kouri Richins was perpetrating mortgage fraud. The house, remember, is just in the victim, Eric Richins' name. Kouri Richins is not on the house. So they are saying that under the prenup, which we saw in both the detention hearing or the bail hearing and in the prelim, that under the prenup, Kouri Richins only takes the property that was gained in marriage and the house and what have you if Eric Richins dies during the marriage, and the state has shown that she was well aware of that fact. So doesn't the mortgage fraud, this is like a Murdaugh argument, right? The mortgage fraud is bubbling up and she is on the precipice of maybe being found out. But now we know that the victim had consulted a divorce attorney prior to his death and was concerned that Kouri was hiding financial things from him and had found out about some of the mortgage fraud. So this financial, the financial stuff is reaching a boiling point. And the court said, isn't it the state's argument that the boiling point that was coming was the preceding detail to her committing the murder, knowing that if he dies during the marriage and if he's looking to leave, then if he dies during the marriage, then maybe she digs herself out of this bubbling shitstorm of financial woes. And so that's really what the state's argument is. Dave asked, is this a replay? Dave, everything in Utah is technically a replay because Utah does not allow court to be streamed. This hearing was on Tuesday. This part of the hearing I have not seen aired anywhere. I think we're the only ones with the footage from early on in the hearing. All I've seen elsewhere is the arguments on bail. So yes, it is a replay. It's not today, but it is, the court doesn't allow it to be streamed, so all of it ends up being aired after the fact.
Money. She was committing crimes in a coordinated way to get the money.
So the slippery slope that you would have to slide down to connect a year prior to something she did in her business to obtain a loan, to somehow connect that to they've not made any allegations that there was a plan to cause death a year before. There's no allegation that she even had they've introduced zero evidence that there was a plan spanning back over a year temporally to her making a decision to take an act in her private separate real estate business that wasn't even connected to her husband. So as far as based on the same conduct, which is what the statute requires, the statute requires it be based on the same conduct or connected together in their commission. And the case law makes it clear that connected together does look at temporal connection. And a year prior with zero evidence of connection is, I mean, it would basically be as if you would just say any crime that they could suggest that she committed, 2 years, 4 years, 6 years before that had anything to do with money somehow must connect to the fact that she ultimately made a decision in their mind to commit a murder for pecuniary gain. And that
Again, so the defense is arguing, look, how far is too far temporally, time-wise? How far back is too far back? A year before these murders, it's just a financial crime. It doesn't show that she's planning a murder. So she's saying, how far back is too far back to bring all of this in? And again, it's why RICO crimes get used the way that they do. So the answer on how too far back is the limit does not exist. But in other cases, she's arguing that the statute does not allow for those mortgage fraud claims to be joined into this murder trial. And she's trying to limit that. I've seen a number of you asking about where Sky Lazaro is, the other or previous defense counsel. I'd have to look back at my playlist to see the date that we covered that. But Sky's entire firm was removed due to conflict. But the prosecution, Mr. Bloodworth, the prosecutor, this is just pure speculation and delight in my mind as I'm writing all of this into a novel in my brain, because if there was ever a case to write into a novel, this is the one. So as I am thinking through Mr. Bloodworth, who seems like, in my brain, I hear Duckworth and we've gone to DuckTales. Woohoo. But Bloodworth spilled all of the tea in his motions when Sky was withdrawing because Kouri Richins was name-calling Sky and her other defense attorney up one side and down the other. And Kouri was on recorded jail calls talking to one of her attorneys, and because that attorney said he didn't want the government's app on his phone to record or put him in the attorney queue with his calls. So he was calling in on the public recorded line, knowing it was a public recorded line, and they were arguing that the prosecution needed to be yeeted from the entire case because they had obtained those calls. The prosecution said, look, the second we realized that the attorney was on the line, we stopped listening to those calls and turned them over to the taint attorney so that they knew that we weren't listening to those calls. But that attorney had every ability to call in on the attorney recorded line or the attorney non-recorded line, not the public recorded line. And that attorney chose not to call in on the recorded line, or chose not to call in on the attorney line, the special non-recorded line, called in on the recorded line and therefore knew that they were calling in. But Kouri was calling everybody, like her mom and them, well, really just her mom and her brother, and bitching about her attorneys. She called Sky a dumb bitch like 4 times. I'm like, girl, really? Because Sky got up in court and fought for Kouri. Like, you can't. I don't know what people in the chat think about Sky Lazaro. We don't normally talk about attorneys unless they say what, if anything, ad nauseum and annoy us. But Sky was down. Like, Sky was riding for her client. Sky was just every single motion she could bring. Sky was in court really advocating for her client. I imagine that Sky also told Kouri the truth. And Kouri probably didn't like that because Sky had all Kouri's text messages that we didn't know about until the preliminary hearing. But Sky probably told her the truth. But Sky was down. Like, Sky was ride or die. I'm going to fight the DAs. I'm going to fight the sheriff's department. I'm going to file every motion I can. Sky is like the Utah version of Brian Steele. She was not going quietly and not agreeing to anything. And so for Kouri to be on jail calls talking about Sky was wild to me. Because again, I think Sky was a zealous advocate. And not just that, but she might also cut you with her heels. So, Sky was here for it. But Kouri shit talking her attorneys on recorded calls, and then the DA putting them in the filings was so fucking messy. I love it. I just loved it. Not that these attorneys aren't down. These attorneys have advocated really well, but also private counsel and court-appointed counsel, sometimes you're going to get a different level of, I don't want to say theatrics, but sometimes you're going to get a different level of, theatrics. Appointed counsel here has done a great job for Kouri. They have filed all the motions you would expect them to file and more. They are zealous advocates, but also they are covering way more cases, I would imagine, than Sky is. So you're not going to see the same level of performance for the media that you're going to see from a Sky Lazaro. So Kouri being a caddy to Sky was not on my bingo card, but it was hilarious. And look, as a criminal defendant, the things Kouri is accused of are awful. The ripple effect that her family has to deal with, that her children has to deal with, that the state is alleging that she caused is horrific. The things that her in-laws, the victim's family, is going to have to deal with is horrific. But Sky's lack of awareness on her jail calls, in her novel, in her children's book, is one of the most preposterous things we've seen. It's just giving full Murdaugh plus. And it sure is something, isn't it?
That's just so tenuous. That's not at all what the statute
So back to pecuniary
entails. I mean, basically, we would be trying two separate periods of time in history, two totally different sets of witnesses, two totally different.
Oh, did I say Sky's lack of awareness?
sets of
Kouri's lack of
exhibits
awareness.
that
I didn't
have
mean to connect
zero
them.
connection, other than the fact that it has to do with money.
I like Sky a
And
lot.
if that were the case, we would see informations that would be way beyond the pale of what the legislature intended and an information to contain. So we would strongly disagree that any allegation of something she did in her business a year before had any connection whatsoever or was based on the same conduct or connected together in the commission with any allegations of what happened a year later. So we don't think that.
I'm going to share my ADHD with you for a minute because I'm trying to follow this defense attorney's arguments, but I'm also sitting here staring at the clerk's hair, contemplating whether or not I need to go back to a jaw length asymmetrical bob because it looks so good on her and I love it. And I, in law school, had an asymmetrical bob that I loved and hated because my hair is not naturally super straight. And so I am now distracted, but she is continuing to argue that the mortgage fraud is too disconnected from the murders in time. Different again than Murdaugh, because those Murdaugh financial crimes were leading up to the day of the murder, right? There was a confrontation the day of the murders that were financially related. Here, it's all the way back. Nishay, I know the haircut has definitely been ruined. It gets a little too close to Kate Gosselin. I get it, but I love an asymmetrical bob right at the jawline, just right at the jawline. Oh, all the way down. I like mine a little more punk rock, at the jawline, all the way down to pointy bits at the collarbone. So that's what I am thinking. But anyway, let's continue on. For those of you asking in the chat, yes, Kouri Richins wrote a children's book about grief. Yes, she argued the Walk the Dog letter was part of a novel about being trapped in a Mexican prison. That's what she said. I've covered that on the channel. We have a full playlist on this case. If you're just tuning into this case and you're like, what in the telenovela did I walk into? Yes. Mm-hmm. Yes.
The mortgage fraud
but make it
cases
Utah.
even survive the statutory analysis. We think they're gone. As far as the attempt charge, I would concede there's definitely a stronger argument on the attempt charge to survive the statutory analysis. The focus.
Camera, I am trying to focus. I don't need a close-up of her waves. If you're going to zoom in on anyone in this case, it's going to be the judge. Thank you.
We don't think that the mortgage fraud cases even survive the statutory analysis. We think they're gone. As far as the attempt charge, I would concede there's definitely a stronger argument on the attempt charge to survive the statutory analysis. The focus on the attempt charge would be more on the prejudice analysis, which is the second prong that you have to get to.
Let's go there.
Okay.
So
Let's go there.
Under 4A, it's the reciprocal
They are arguing two things. Sorry, Your Honor, hold on.
admission.
Better. The defense is arguing two things. First, the defense said, in case you're all distracted like me this morning, the defense said, first, there is a statutory analysis to be done on joinder. Are the mortgage cases properly joined or the mortgage counts properly joined to this? Are they too temporally far? Are they too tangential? And then she switched to the attempted murder, saying the attempted murder is more of a prejudice argument. The attempted murder actually holds, she said, or conceded in the statutory argument. The attempted murder is more related for proper joinder, but she's arguing it's too prejudicial. Because if you hear that she's accused of poisoning her husband on March 3rd, that's one thing. But if you hear, well, on February 14th, the husband got very sick, the doctors have determined that come in, or the experts have determined that sickness is consistent with fentanyl or or an overdose of fentanyl, that you see text messages in the days leading up to him getting sick on Valentine's Day that she was purchasing fentanyl. And then you see text messages after Valentine's Day where she's asking for something stronger, and then he's killed. When you see journal entries, because Dear Diary, her journal entries indicated that she learned that she needed a lot more fentanyl after Valentine's Day, that you see that she drops off the breakfast sandwich, that she bought it herself, that that's what he had eaten, et cetera, et cetera. So does that become too prejudicial, or is that part of the same scheme and plan? Liza Joe in the chat asked, was the dealer arrested? The dealer, by the time this came down, because the murder happened in 2022, she was not arrested until 2023, more than a year later. The dealer was already in custody on other things, and it seems that the dealer has a level of immunity for this. So, James Randolph, no, I'm not being hyperbolic. That's all from the preliminary hearing. I'm not being hyperbolic about what she wrote in her diary. That came in during the prelim and during argument. This trial is going to be wild because there's more we don't know, and there's a paramour, and there's all the things. There's all the things, and then there's this judge. Could we love a trial more? I'm ready. All the tea, and this judge. Again, it's a really deeply sad case, but it's hard not to be a little bit lighthearted with this judge. We like him very much. And so far in this courtroom, we don't have all of the ick that we had the last time we were in Utah for Gwyneth Paltrow, where everyone was sick like I am today. And it was just an entire trial of people just nodding and coughing and mess.
Test, right?
Right.
404B.
That's correct.
My understanding
Reciprocal
is we have to do
admissions.
both. Would evidence regarding the attempt be admissible in a trial regarding the actual homicide?
That's
and
correct.
vice versa, would evidence regarding the actual homicide be admissible in a trial of the attempt?
So go to
That's
the evidence.
Talk to me about this.
So we kind of did this on.
So the court is saying, and I know it's hard to, I'm having a hard time focusing today, which is why I'm reiterating it, and then I'll stop doing it to the best of my ability. The court's saying we need to do the 404 analysis. Is the evidence of the attempted murder admissible in the murder case, and would the murder be admissible in an attempted murder case? You need to prove both because they're properly joined. So is it too prejudicial? Is it more prejudicial than probative? Or is it more probative? Things can be prejudicial. A criminal trial is prejudicial. It's just where it outweighs.
Argument exhaustively at the prelim.
We did, in fairness,
Yeah.
I
Different
was
standard.
unsure,
Yeah.
right, how it would fall out.
Yeah.
I've since had some time
Yeah.
to dig. There's no reported case in Utah to this effect, but courts in Illinois, Virginia, and then the Fourth Circuit Court of Appeals state explicitly subsequent events are admissible under 404B. It's not prior bad acts only, even though that phrase is used
It's subsequent acts.
all over the place
Right.
in Utah's reported case law.
Right.
And the text of the rule says other bad acts, not prior bad acts.
True.
Does the defense have any quarrel with the idea that subsequent acts are the subject of a 404B analysis?
I hate to concede that. I certainly respect the court's position and argument that you're making. I don't think I'm in a position to concede that because it is not super clear in Utah law, and this is a case with a long life ahead of it. So I don't want to concede that. I do believe
That's the law. I don't want to
that
concede it, but that's the law.
The stronger perception, the stronger perspective, if we're arguing whether or not the attempt charge should be tried with the murder charge, is the position that we're standing on is similar to the position that we argued in front of you at the prelim under a different standard. But the idea is that the lack of evidence in terms of the attempt charge. There is the case law that we referred to in our brief does suggest that the strength of the evidence is something that you do look at when you're trying to decide the prejudice analysis.
We don't really do Shickles anymore, but I take your point.
Yeah. And the concern that we have is that you have the aggravated murder charge, which the state has, that's where they're putting their eggs in their basket. But as far as the attempted murder charge, they have no medical proof, they have no suggestion, they have no evidence of what was ingested, if it was a allergy, if it was a stomach virus, if it was whatever. And the problem with that is that by bringing that into this case, and it's temporarily separate by about a month, right?
That is less than a month,
little
ma'am.
less than a month, a few weeks.
Mm-hmm.
And that the prejudice that would...
She's trying to argue. She is doing her job. This is a harder argument than the previous argument. The defense knows how bad it looks if you try to kill someone, ask for stronger shit, and then they die. It just gives a different chain of events. It also gives a different chain of events to premeditation, right? Oftentimes in homicide cases, when you are trying to explain premeditation, you're arguing to the jury that premeditation, that decision can be made in an instant. That decision can be made quickly. Picking up a weapon and then loading it can be enough to argue premeditation. Those decisions can happen quickly. In this case, the prosecution gets to get up and say, let's talk about premeditation. She found someone that could procure her the thing. And there's text messages over days of her trying to procure fentanyl. And then she went and picked it up. Then she made a plan to get the breakfast sandwich. Then she went and drove to wherever and bought the breakfast sandwich. Then she laced the breakfast sandwich and gave it to him and then left the house to go be with her paramour while supposedly, and this is all alleged, while supposedly leaving her husband at the home to die. And when he texts her and says, I'm not feeling well, she says, maybe you should lay down. Ain't it dark? Wrapped up in that tarp, Earl. Maybe you should take a nap. You feeling weak? Maybe you should just lay down and sleep. Just go ahead and take a nap. Then he doesn't die. Then she reaches back out to her dealer and says, I'm gonna need something stronger. Then, dear diary, what I learned today is that actually the news has been lying to me. People don't just die from touching fentanyl. It's actually way harder than everybody's made it out to seem. So I'm gonna need more. I think the word she used was a truckload more. Then 3 weeks later, she's like, we're going to celebrate. Makes him a drink, gives him the drink, and then goes and sleeps in one of the kids' rooms and leaves him alone in the bedroom. And then comes back into the bedroom later and goes, oh no. And then goes and does stuff in the house and then calls the police. And the police come in and she goes, oh no. And then a year later, while she's on a book tour with a children's book about grief that's not going to come in a trial, they arrest her after getting all the text messages and all the rest of the stuff. So the argument on premeditation is not a decision can be made at a second. It's like, man, she's been trying this for well over a month and a half. And what she did is learned from what she did the first time, and then she attempted to improve on it the second time so it would reach the desired result, in this case, murder. The closing argument for the prosecution writes itself. There's no argument about premeditation. What the defense is trying to do is to separate the two. Hey, it's real bad. It's real bad in the murder trial if they get to also show the attempted murder. It makes it worse because everything I just said. So they want to separate those two. And the judge goes, okay, well, to decide if evidence is admissible, we need to decide if in a murder trial, would a prior attempted murder be admissible? And, arguendo, in an attempted murder trial, would a subsequent murder be admissible? We need to check those two things against each other, and that's what they're doing now. Because is it more helpful to the jury, more probative, or is it more prejudicial, damaging to the defendant? It can be prejudicial. In this case, I would argue it's prejudicial AF, but it doesn't mean it's not more probative. Does it help the jury determine what happened here? And is it too far in time, or is it close enough in time? So for those of you asking if I'm being hyperbolic, only in my quoting of the chicks and my shocked Pikachu faces, the rest of it came in argument and at the preliminary hearing. So no. I'll let you know when I'm being hyperbolic, because in this case, it's hard to tell the difference. The diary, though, the diary was new at prelim, and I was like, what?
Outcrop from that, when there's such weak evidence on the attempt, would be overwhelming in terms of if you do a probative value versus prejudice analysis, right?
Yeah,
So
pause for a minute.
yeah.
Pause.
We can skip to 403 if you want, but let's stay with 404B for a
Okay.
minute.
I love this
So
judge.
the issue
Pause.
is this other acts evidence that fall?
I think Kouri likes this judge too. Look, if you're going to get dragged into court every single day, you're up at 2 a.m. or whatever to get to court, I think Kouri likes this judge too. That's just how I'm reading the situation.
Falls in the propensity bucket or some other proper purpose?
Well, I think I'm going to leave that to the state to argue. I don't
The
want to make
state
their argument.
argues
The defense is like, nope, I'm not
several.
going there. It's a
Right.
trap,
The
Your Honor.
ones that stick out to me are preparation, plan, intent.
Right.
Now, depending on which direction we're talking, not all of them apply.
Is it a new tattoo? What are we, is it a new tattoo? What are we doing?
Preparation and plan, in intent, all three seem to apply as non-character purposes when discussing whether evidence of the attempt would be admissible for the ag murder charge. We have the state's theory of securing fentanyl, administering it to Eric via food or drink, and then leaving the scene to have deniability. That's their theory of the case.
I'm trying to gain this up a
Theory
little.
is that she did it in February 14.
Because he's going to reiterate the state's case, I think, really well, or the state's argument really well. So I was trying to gain it up a little bit, and it didn't help nearly enough.
We have the state's theory of securing fentanyl, administering it to Eric via food or drink, and then leaving the scene to have deniability. That's their theory of the case.
Right.
And their theory is that she did it in February 14.
Right.
It didn't work. She asked for something stronger. She did it again in March, and it worked that time.
Right.
So there seems to be a non-character purpose under 404B. We can talk about whether the probative value of the February 14 events is substantially outweighed by the danger of unfair prejudice, not just prejudice. If it's not prejudice, it doesn't matter.
Right.
It's prejudicial.
And the court's right on
because
that. What the court is saying is if it's not in a criminal case, when you're admitting it against the defendant, if it's not prejudicial, I mean, you're trying to convict someone of a thing. If it's not prejudicial, is it even relevant? Because if it's not prejudicial, it doesn't really go to show a fact, right? So the judge is like, right, it has to be unduly or unfairly prejudicial. So the court is really walking us through like evidence 101. How are we doing these balancing tests? Not only is it relevant under 403, but under 404, is it being used for a improper purpose?
it matters.
Right.
So
Or a
tell me
proper
why
purpose.
it's unfair.
Well, I think it's unfair because
I forgot to
the
take my
entire basis for the allegations of the attempt are based on pure speculation. There's zero physical evidence, direct evidence, nothing. So
It's circumstantial.
correct. at best.
Still proper evidence.
I would say pure speculation. So the problem that you have is if you bring that in and you allow them to make those leaps to create a character analysis, which, by the way, at the preliminary hearing, the prosecutor absolutely got up and made a character argument.
We would certainly have to instruct the jurors that they are prohibited from drawing any character-based or propensity-like conclusions.
Right, but I mean, this is so overwhelming in terms of prejudice that, you know, to unring that bell is not realistic, I think. Even the best crafted limiting instruction is not going to be able to eliminate the damage that that type of prejudice is going to do to a jury in the box.
And that's why they don't want the attempt to come in. Because if the jury finds that Kouri did the attempt and then wrote the thing in the journal, sent the text messages that they've shown that she sent, there's no evidence that those aren't her text messages, sent the text messages, and then followed through. If the jury finds all that, is it prejudicial? Yes. Does it make it seem more likely that she killed her husband? Yes, but is it because she's a bad person? Is it character? No, it's just actions. So that's where the state's going to argue these are the actions that happened. The defense is trying to argue, look, this is so prejudicial that they have to be separate trials. You can't have them in one trial because there's no way the jury can separate out judging her as a person or using it as a propensity, like, oh, well, she's just murdery, or using it as factual. I think it's factual enough that they can say these are all the facts. All these acts together look like you did the acts versus, oh, well, the first thing makes it look like you're the type of person who would do the second thing. That's the fine needle that they are trying to thread on this, which is hard. These arguments don't work if there's like a string of robberies being like, well, Your Honor, we have to try all these separate because you can't say, look, these 7 robberies at a 7-Eleven, it makes them look like they're the type of person to commit robberies. And the jury might think that that's a propensity argument where the DA would come in and argue, these are factual and they're a chain of events. So that's the argument.
So we do believe that as far as the attempt charge goes, that the key things to look at are the fact that it is being used for character. I don't see how...
Tell me why you think that is the conclusion the court should draw here?
The same reason that the state stood up at the prelim and said she did it once, she learned, she did it again, right?
Why isn't that preparation, plan, and intent, or rather she's a murderous person who tried twice?
Well, it's so intertwined with propensity. How do you unwind that, right? Like, it's completely intertwined with propensity. So the argument being that, well, she did it, if she did it before, she must have done it again, right? And so that type of prejudice is just devastating to a defense, and it's based on zero evidence. There's no evidence of it. So to allow I think the 403 almost kind of trumps the 404B argument in this case because of the fact that there is no evidence of this. There is no evidence that Eric Richins on February 14th that he ingested anything that was given to him by Kouri, that he had that he had controlled substances in his body, that he himself made statements that he was having an allergic reaction. He took allergic medication. It addressed the problem, and he had a normal day after he took a nap. So to make this leap and say that because he had an allergic reaction on a day 2 weeks before he died means that Kouri Richins tried to kill him is prejudice that we cannot surmount and has zero probative value because there's just no support. There's no support for it. So we would ask that severance be made on the 403 and 404B analysis. We would concede it's probably going to survive the statutory analysis,
right?
The attempt charge.
What about going the other way?
Letting the murder into the attempted murder?
I appreciate
Really
this defense
question.
attorney's argument because the defense attorney is zealously representing her client and is still very grounded in reality. So even though she's making the arguments, she goes, I concede that it will probably survive this analysis, but arguing here, and I find that particularly with defense attorneys, it is incredibly well taken by the court when there is an acknowledgement of, I concede that on these grounds, we're probably not there, but we're preserving our argument, and then putting the weight of the argument into the grounds that are better taken. And instead of belaboring a point that is really not going to get you very far, I find that it is incredibly persuasive to the court when you acknowledge where they're at, because then they're more willing to work with you. When you argue on everything with the same level of vigor, it can get lost. If everything's a 10, then nothing is. But when you really highlight or pinpoint the key arguments and then preserve the other arguments, it's much better taken.
Question. Since I'm only trying to sever out the attempted murder, I hadn't made the opposite analysis
But
yet.
imagine the state, for whatever reason, elected to try count 2 first and wanted to admit evidence of what occurred between February 14 and March 4.
I would object.
Walk through the analysis for me. Because I think I have to do both.
Yeah. Well, I don't think you have to. I think you can. I don't think you're required to.
The Court of Appeals talks about a reciprocal analysis.
It does. But I think when the remedy we're seeking is only the forward severing.
Fine, we'll do it your way. Imagine that the only count on the verdict form is count 1. And they want to admit evidence of what occurred between January 2022 and February 14. Is it coming in? You
Well,
would say no for all the reasons you just explained, right?
I would. I would say no for all the reasons I just explained.
She's like,
But
yeah.
if they go the other
Still.
way, and the only count on the verdict form is count 2, and the state wants to admit evidence of what happened after February 14.
So the judge is saying arguendo, if the only thing charged is the attempted murder, can the prosecution use the murder after the fact to prove the attempted murder because it happened? So that's what the court is asking now. Can you
Walk
go
me
the
through
other way?
analysis.
Well, I think there's a pretty strong argument that it's wholly irrelevant if they're only trying the attempt charge. The fact that he ultimately passed wouldn't change. I mean, the
Why doesn't
offense
it
is
go to
concluded.
intent?
Well, because the offense is concluded as of the unsuccessful attempt, right?
Right, but we're talking about circumstantial evidence of pre-February 14 intent based upon events, actions, statements made after February 14.
I mean, I don't know. It's an interesting question. we
I
kind
think
of
I've gotta
had
turn
this
down the
discussion
game
at the
'cause the background
prelim.
noise
Does
is
it
killing
mean,
me.
if it happened later, that it must have happened before and vice versa, right? And I think that goes to how intertwined the prejudice and the propensity arguments all are, and how this prejudice is just really overwhelming. Honestly, to me, this does seem
Sorry, y'all. I had to.
unnecessary
had
to
to
try them together
turn that down a
because
little.
of the fact that if Ms. Richins were to be tried for the aggravated murder charge and acquitted, it seems highly unlikely she would be convicted separately of an attempt. If she were convicted of the aggravated murder, why in the world do you need to have a separate trial on the attempt? So basically, we're risking reversible error here and a new trial on
Don't
a
say that to a
count
judge.
that, for all intents and purposes, is secondary and not likely to change the needle either way. So, I mean, to default, to avoid error, to make sure that the case
just
preserves in the
show the
least
judge we don't-
proceeds in the least prejudicial
This
way.
defense attorney's making great arguments, but can we just show both of them? Just everybody, please.
possible for Ms. Richins and that she gets the fairest trial possible, we should sever out the attempt charge, worry about that later, which is probably never, because either way, it's going to be decided by the aggravated murder charge, one way or the other. If she's convicted
if she did both, she should be convicted of both.
of aggravated murder, she's in jail for life. And what in the world do you try the attempt for? If she's acquitted, there's no way they're going to convict her of the attempt with no evidence of drugs being provided to him at all.
I appreciate her
so
argument.
to
I
me,
just disagree.
the safest, most cautious, most judicially economy argument would be to sever it, to eliminate this risk of prejudice, which we will most certainly argue if there's ever an appeal in this case, and to just focus on the aggravated murder charge, which is what the state is here to do. And that's what we're asking the court to do on the severance.
If she tried to kill him and then did actually kill him, she should be tried and convicted of both if she did both.
But even if we did that, I would still have to contend with the 404B and 403 analysis regarding the events between January 2022 and say
Yes.
March 3rd.
Yes.
And I still have to decide whether it's coming in.
Yes.
If I decide that it's admissible,
Right.
then there's no basis to sever the counts.
Right, but I mean, we're arguing it's not admissible for all of these reasons, right? We're saying that it's less probative, it's unfairly prejudicial, that it shows propensity for all those same reasons, and that there's just no substantial evidence backing it.
It shows a common scheme or plan more than it shows propensity. It shows planning, opportunity.
Sufficient to overcome the undue prejudice. So that's the same argument that we're
I
making.
don't think the prejudice is
Okay.
undue, but that's
And
me.
then, as I read your motion, no objection to trying the January 2022 insurance fraud / forgery counts and the June 2022 insurance fraud count with count one, the aggravated.
I think after reviewing the facts related to that and reviewing the statute, I think it is going to survive the statutory analysis. And as far
I love the defense is like, well, I'm not arguing that because it's going to fail. So we're just going to let it go.
as severing it, I mean, it's just, we're not asking for those to be severed. We admit those are properly joined.
Okay.
But it's just the mortgage fraud and the attempt that we are now attempting. And now that they've dismissed the distribution, that would have been part of it too.
Understood.
Okay,
I'll make sure you get the last word.
thank you, Your Honor.
All right. The court said, I'll make sure she gets you get the last word. And that is the end of the video that we have from the first part of the hearing, which I find frustrating, but it just is the way that it is. All of you are like, no, we want to hear the rest of the argument. I want to hear the rest of the argument too. And I did on the audio. So I'm going to go through what happened at the rest of that hearing in the other hearings, because again, we don't have the full audio. I am still working on trying to get it, or the full video. I am still working on trying to get all of the video, but no one seems to have the full video, and all the media outlets have only shown the bail hearing, which is what we're going to get to. But that camera person was there for the entirety of the hearing, which included a break. So I am incredibly frustrated, but we're going to go to my notes of the rest of that hearing. I think it's more helpful if we do it in order than if we just jump to the bail hearing now and then do it do it at the end. So I'm going to finish up going through my notes, and then we're going to go to the bail hearing that we have. So let's get to my notes from the rest of that hearing. I'm bummed because it was actually a really thorough hearing on that motion to sever. Again, Kouri Richins here. Let's pull up the information while we're talking about this, because I think it's the most helpful to have, as we're talking about motion to sever counts. We might as well just look at the counts together, and then we'll go to that second part of the hearing. So let's pull these counts up as we're doing it. So the defense is arguing that count 1, the aggravated murder, and count 2, the attempted murder, should be tried separately. That is the core of their argument. That is the thing that they want the most. But they are also arguing well, they were arguing counts 3 and 4. Those have now been dismissed. So then they're arguing that the mortgage fraud counts in 5 and 6 are too far in time. That's June 29th, 2021 and August 2nd, 2021. They're saying that this is not connected enough to the murder, either in time or in common scheme or plan, to even meet the statutory definition of joinder. So their argument is these are improperly joined into this murder case because they are too far in time. These, again, June 2021, August 2021, and the murder happening in March 2022. So she is arguing that those mortgage fraud should come out, and then these forgeries, 9 and 10, those forgeries are directly related to the mortgage fraud. She started to argue the insurance fraud and said, I admit that these probably meet the statutory definition. Lovely Hope, I addressed a little bit about the full audio at the beginning. The court has really strict rules about that audio, and the audio call-in is not allowed to be streamed or broadcast. This judge, and we'll talk about it later, this judge is real salty about any media, and I am trying to stay on this court's good side because I don't want them to get rid of their audio access program, which so many courts have done, because it benefits all of us so much to not have to fly to be in court or to just rely on the snippets the media chooses to cover, which in this case was only the bail part of the hearing. So because the court rules are, I think, very clear and stringent, I'm very mindful of that. So no worries. No worries. But there are times I'm very much a rule follower, and there are times I will push the rules, but I don't push it when the court gives access with very strict rules. So the motions to sever were trying to get rid of the mortgage fraud, the attempted murder, and the forgeries that went with the mortgage fraud. The defense conceded that the insurance fraud is his life insurance after the murder. So the defense conceded that those are connected in time and those are connected to the same course of events. If someone dies and then there's insurance fraud to try to get to their life insurance, then or they fraudulently set up a life insurance and then within a few months kill them, that could tend to show that there was a plan in place, because these insurance policies were taken out January 29th, 2022, and the attempted murder was February 14th. So how do you think the insurance company handled that, Chad? But if you have that close in time between January 29th and February 14th, there's, I think, an argument that there was a plan that he would no longer be with us. So she conceded that severance. What happened next? So we ended with the court just now allowing the prosecution to make an argument. The prosecution argued, as they had in the past, that the boiling of financial circumstances, essentially, that the financial temperature was rising and she knew she was only going to get money from the estate to get out of all the financial trouble and save her business and what have you if Eric died during the marriage. Then the defense got back up to argue the severance and really made, again, the same arguments that if the attempted murder is allowed in the murder trial, there's no way to unring the bell. The jury is going to use it for propensity, which is improper, not using it to show common scheme or plan or other proper things. The judge at the end of the day was persuaded in part and not persuaded in part. So this surprised me a little, but after the judge explained it, and I really wish we had that because the court went through an incredibly thorough oral ruling, but the judge ruled that the mortgage fraud cases and the mortgage fraud and the forgery were going to come out. So the judge ordered out counts 9 and 10 and counts 5 and 6. The judge said that they were not temporally linked, that they were essentially too far in time, and that the danger of them being used for improper purpose was too great. So he found that under the statute that the mortgage fraud and the forgery to the mortgage fraud were too temporally separate. Therefore, they were not properly joined. So for Kouri, that's a fairly big win. The mortgage fraud coming out takes out that whole background of her taking out loans on the house. It takes out some of the background about the financial problems. The indebtedness, and I see you guys already asking, the indebtedness can still come in to show motive. So the indebtedness and her knowledge of the prenup can still come in to show motive, but they're not going to determine the mortgage fraud. Those are going to be separate for a separate trial. Or what happens oftentimes, if there is a conviction, she might plead to these so she doesn't have to do a trial again. She might not. She might enjoy coming to court. What would you do? You're Kouri Richins. You don't necessarily, maybe you do want to go to prison. I don't know if the conditions in prison would be better than in local custody. Maybe you do just want to go to prison and do whatever you're doing in prison. Maybe that's what you would like to do. But if you have a second trial, would you rather just come to a second trial with this judge, or would you rather just plead those out so you don't have to deal with them again? I don't know. So sometimes courts a change of pace. I mean, why not? If it's the same judge, are you just like, well, hey, Your Honor, let's talk about mortgage fraud. Let's see what they think. Well, why not? So the judge severed the mortgage fraud and and forgery counts. But the court did not sever the attempted murder and the insurance fraud from January 29th. So what she will go to trial on at this point is, sorry for all the scrolling, is the murder, count 1, the attempted murder, count 2, and then the insurance fraud. So the trial gets narrowed really to those topics and allows for some of the indebtedness to come in because some of the information about the prenup will come in because the prenup goes to motive and her text messages and life somewhat reflect that. So if this trial ends and they want to go to trial on the mortgage fraud, then they can. If they want to do a time served plea deal, then they can. If the state wants to drop it, then they can. We'll see if the state pursues the mortgage fraud more after the murder trial. They may not. So we'll see. But the mortgage fraud and then the subsequent forgery counts come out, and this becomes a 4-count indictment. I think the judge, after looking through his reasoning, I think it was a considered and careful ruling. I also think it preserves the case. I also think some of the evidence that the state's going to want to come in will come in, as I said, under motive. So do I think it's a win for Kouri? Yes. Do I think she'll be happy with that? Yes. Do I think her defense attorneys will be happy with that? Yes. Is that their only win for the day? Also, yes and no. The next motion that they heard was their motion to seat 12 jurors. In Utah, the law is 8 on a non-capital case. This is a non-capital case. The defense argued for 12 jurors. The judge, in his ruling denying that motion, said essentially, and I was typing frantically while he was talking through it, the judge said, at the end of the day, when I put on this robe, I am to uphold the law of the land as it is. He said Utah might be on the wrong side of history on this, and a state may choose how many jurors to seat. A state's refusal to seat 12 jurors does not violate the 6th Amendment as it applies to the states through the 14th Amendment. The court is required to follow Utah law on this matter. The law in Utah is that on a non-capital case, the jury is comprised of 8. And then he said, I look forward to seeing that law change, but until it does, I must deny this ruling. So the judge let it be known that he was empathetic to the argument of the defense, but also, while I'm empathetic to your argument, while I think this law should change, while I think 12 in a first-degree murder case is appropriate, essentially, I put on the black robe and I said, I will uphold the Constitution of the state of Utah and the laws of the state of Utah. And so even if I personally disagree, It is my job to uphold the law of the land until it is no longer the law of the land. And so you can preserve the argument, but this has gone up to the Supreme Court, and the Supreme Court has said it is up to the states to decide. And so when it is up to the states to decide, then the states get to decide. So then the advocacy in Utah becomes, should this change for first-degree murders? And I think, in fact, though I was joking about Florida seating 6, I think it is 12 in Florida for first-degree murder and 6 for the second degrees. But in Utah, it is 8 for anything that's not a death penalty case, which is interesting. So I can understand why the defense is preserving that argument for appeal and saying, no, it should be 12. So I have a lot of respect for the judge, and it's rare that you see the judge making a statement of personal opinion on a ruling. And so it was kind of a unique thing to see the judge say, Utah might be wrong here. I would like to see the law change, but I took an oath and the robe comes first. So I'm empathetic, but I have to follow the law, and this is the law. And I think that's a really interesting ruling, because you don't often see judges make statements like that. And again, which is why I hope we would have it on video. Next, the motion to expand the veneer. Utah says venire. At some point, we're going to take a survey across this land. I'm going to get a map and just put in a map which courts they say veneer, which courts they say venire. And then we're going to go tell the venire courts that they are all wrong. Emily, the hypocrisy, bitch. The hypocrisy of you telling anyone how to pronounce anything. I know. The brazen hypocrisy. However, veneer is correct. So the defense made a motion to expand the veneer, the Commonwealth. We're not in Massachusetts today. The state stipulated expanding the veneer means they grab jurors from more counties than just the county that they're in. The court allowed for that and said, yes, we can expand our net, essentially. So we can pull jurors from Summit County and then from 2 surrounding counties. So we can pull everybody in. The court said, counsel, I have confirmed with the powers that be in the mothership that this is possible for us to do. So the court had gone through all the court administrators and asked all the court administrators, hey, we've never had this come up, but how do we do this? We have a high profile media case. How do we grab jurors from outside our jurisdiction? A lot of states have laws that say how far you can travel from, though I don't know if that's true in every state. Los Angeles County was such a big county that if you live in, I don't know, Pomona, and you got sent to jury duty in Torrance, it would take you 2.5 hours, if not more, to get to jury duty. So Los Angeles County had some mileage limitations on jury service, just because you could pull jurors from opposite sides of the county and it'd be 4 hours away. But that's a unique thing to a county that is that large and densely populated. I imagine that in rural counties that are geographically large but not as densely populated, they don't have the same types of restrictions, because if they're not densely populated but they are massive, you would need maybe to pull from outside the county to get enough jurors in a given case. Either way, they're pulling in more jurors, and they're allowed to do that. We can tell stories another day about the trauma of being reassigned, because when you're a DA in LA County, you can work anywhere in LA County, but depending on where you live in the county, that can be real bad. We can talk about the trauma another day. There were a whole bunch of lawsuits over it with this last administration. The taxpayers of the county of Los Angeles are paying millions in judgments because of the retaliation from the former, well, I guess he's not out yet, but the soon to be former district attorney who retaliated against people. Freeway therapy is not appropriate. You can't just retaliate at work. We've digressed. Anyway, they've expanded the veneer. They're going to be pulling in jury panels from multiple counties near Summit County. So they're going to randomize a list. They're going to pull people in. The parties are going to talk about how to practically do that, but it's granted. Stipulated by both. Then there was a motion on in-person jury selection. This blew my mind. I wish we had this on video. blew my mind. Summit County is doing remote voir dire. I can't even fathom what it would be like to try to pick a jury remotely where all the jurors are like on Zoom. Like, what? Like, I did a lot of trials, like a lot of trials. And one of the things in jury selection is not for me, and this is, I mean, every attorney is different, but for me, I would look at what jurors came in carrying to read. I would look at how jurors sat in the veneer, if they were uncomfortable being there, if they seemed comfortable being there, if they would look at anybody, if they wouldn't look at the defendant. Like, I would look at their behavior and body language from the moment they came in. Because again, I have had juries that hung and I could tell. And I didn't have reason to kick a juror, but I could tell. I was like, oh, that one doesn't want to agree with anybody. Like, you can tell. Sometimes there are just personalities that are like, it's going to be my way. And if you have one person that's going to put their foot down at the very beginning and not deliberate, you're going to end up with disagreement. Sure enough, that jury hung 12-1 for guilt. And the one person was still like this the whole time. But I would look at jurors from everything, because you're not just picking jurors, you're picking jurors as a group that will work together and that will work together as a group. You want people who are willing to work together as a group. And so trying to pick on a Zoom screen blows my mind. But that is what is being done in Summit County. They had a long discussion about what happens if there are technical difficulties, which, can you imagine? I still get on a Zoom call with my fucking mic muted. On our team calls almost every week, they're like, girl, it's been 4 years, your mic. It's like, oh, right, it automatically mutes me when I come in. Not to mention, if you watch court and Zoom court, the probability for people to try to intercede into that, we have seen in courts. People trying to unmute themselves and impact or say things or have a moment. There's just more room for fuckery, really, and it concerns me. But the defense was arguing all of the things I just said. We need to evaluate. You also want to look at who's up next. You want to know, okay, if I kick this juror, who are the next 4 jurors in line? It is strategy. And I think the most important strategy in a case. And if you cannot read people well, jury selection is going to be miserable. But if you can get a sense for people quickly, which is where I think people who are neurodivergent really work well in law, because sometimes we can read a room really well and sometimes we can't. In court, it was much easier for me in social situations, or than in social situations. I could read the room. And so when you can read the room well, you can try to find a group that's going to get along. So not being able to read the whole room, I think, would be a horrible disadvantage. And those are the things the defense argued in this motion. We need to be able to read the room. And, Your Honor, there's extraordinary circumstances here, which is one of the things that Utah has carved out to do in-person voir dire, is extraordinary situations. Rexy Moto said, wasn't there, yes, there was NSFW audio in one of the cases we were covering. Yeah, in the bench jumper, the Redden trial. Yeah, there was. That just blasted over the court from the Zoom call in Redden. So the defense argued all the things I just said, and then said the extraordinary circumstances here is that there is an intense amount of media attention. The prosecution agreed. I think the prosecution coalesced the argument better for the judge. The prosecution argued that you can't know if the jury is going to understand what media attention means unless they're there. If you're not walking into a courthouse with media, if you're not sitting in court seeing the cameras, you don't really know how it's going to feel. You can think that you can be fair, and then you walk into court and you feel different. because now you're seeing it and it's real. And so the prosecution leaned in a little bit more to, we can't really know if the jurors are going to be okay with it and able to be fair, because that's a for cause kick. Able to be fair in the light of these things in the courtroom. And I think the pools do a great job. And we've seen, we saw that really clearly in the Depp Heard case. We saw it really clearly in the Paltrow case, where the cameras were just kind of a wrapped black stand, and there was a little remote camera over the witness stand and a couple other ones, and they were fairly indiscreet, or they were fairly discreet in the courtroom, and they were not a person sitting with a giant TV camera swinging it around once you got to trial. So you can't know what it feels like. And I was chatting this morning with Judge Abby. It's different. It was even different for me on days that I would go into court. And in LA, we dealt with media cases. And there were days where you walk into the courthouse where there is so much media that it changes the energy. I don't know if everyone's as sensitive to that as others, but you can feel it. All the deputies are on a little bit of a heightened alert. There's a lot more of them. There's a lot more law enforcement presence. There's media everywhere. Media's pushy, man. I could never, but especially when you're getting into like TMZ media, like media will swarm in together, and it is a lot of people, and the energy feels different. And so walking into court on a day like that, where even the outside of the courthouse is full of media, even if it's not for your own case, feels different. Dude, the Lindsay Lohan days, when she was in court at my courthouse, the media was wild, the amount of media. And so it changes, vibes. And so if a juror is going to be incredibly overwhelmed by that, if driving up to the courthouse with a line of local media, the media in this case, I don't think will be like the media in like the Lohan case. Maybe it will. But if walking through that amount of media from the parking lot every day is going to cause a juror anxiety, the defense and the prosecution and the court need to know that. And you can't know that when somebody's sitting at home on their Zoom going, oh, I'm fine with media, because you don't know. You just don't know. I thought that was a very persuasive argument. The court was not friendly to this argument at the beginning. The court was like, no, we do this for convenience of the jurors. We have done this on WebEx for numerous trials. I do this in a lot of trials. It's not like we've never done this before. If there's technical difficulties, we dismiss the juror, just like if they fail to appear. We've got this set up. We know how to do it. The state was like, look, Your Honor, we were picking a jury on a much less serious case, and we still had hours of technical difficulties, and our jury selection took twice as long because of it. And the court then started to talk about protecting the jurors. And the court said, and I'm reading this because the court is ready to fight on this. The court said, quote, the extreme level of media attention is the extraordinary circumstance in this case. He kept calling it extreme. And he said it, the extreme media. And I'm like, oh, Your Honor, you know how I know that there's not an extreme level of media attention in this case? It's that I can't even find the full hearing. It's that no one is in court fighting for this to stream even on a 1-hour delay. It's that there were 5 motions on calendar and the headlines addresses only 1. That is not an extreme level of media. We are at a meh level of media at this point. Like, there's one media outlet there. There are other journalists in the seats. I've seen them file to be there, like Dateline and whatever. But this is not even close. I wonder if this courthouse, Summit had the Paltrow case. This isn't even as much media as that yet. So the court kept saying the extreme level of media. And he said, this is extraordinary media attention from legacy media, from new media, from blogs, from video blogs, from live tweeting. He said, my ability to protect jurors from outside influence and the bottleneck of the front door and driveway is 0. I can block the media from jury selection, and there won't be any ability for the jurors to be seen by the media or have their license plates photographed, etc. This is something he's very concerned about. But you can have them park off site and have them bust in, but whatever. He said this level of media attention is a relatively new thing. The state and the defense both argued, actually, there have been high-profile cases for like as long as we can talk about. Some of the cases that got cited in the Koberger case involved a Supreme Court case where the jurors' names and home addresses were put in the newspaper. So we have come a long way in protecting jurors' identities in court. And this level of media attention is different because there's more avenues of media, but it's not new. So when we are in the Supreme Court cases we were looking at are from like the 60s. That they were arguing, well, that they argue in all of the cases about the balance between media access. And then the court said this level of media attention is a new thing. The defense and state kind of pushed back on that and said this isn't new, but it is different. The court said, I'll be picking a First Amendment fight with the media over jury selection, counsel, but that's not your water to carry. And I was like, oh boy. Oh boy. So the court is already ready to even limit jury selection to a closed courtroom. So that is going to be a First Amendment fight with the media, because now the media is on notice that he wants a closed court for jury selection. Jury selection is often not streamed, but it's normally an open courtroom. Media can come in and sit and listen to jury instruction. They can take notes. The courtrooms are generally open in person. They don't have to make them open via a camera, but they can't close them. So if the court is trying to close the courtroom, that's going to be interesting. But also, if the cameras are in the courtroom for jury selection, they don't have to be on. Sometimes you just get audio of jury selection. They don't have to be on, but the jurors need to see what it's going to look like. So the court has already indicated that he's going to pick a fight with the media over jury selection. And the court said, maybe jurors wouldn't be as open and forthcoming in a courtroom full of people as they would be if they were at home. And maybe them being at home will allow them to be more open and allow them to be more forthcoming. And the court took after that a 30-minute break. But the court said before the 30-minute break to both sides, because both sides want in-person jury selection. And the court said to both sides, when do you need to know by, and if this motion is denied, how long do you need for an interlocutory appeal? And do we need to address this before our next motion? And the defense said, well, Your Honor, when we need to know by is something that might change depending on your ruling on the next motion being the motion for bail. So the defense is like, well, if you're going to let Kouri out of custody, then we'll have time for an appeal. If you're not going to let Kouri out of custody, then things might be different. So when the court came back from a 30-minute break, Nishay asked, thank you, Nishay, because I know you're asking what everybody is thinking. What is an interlocutory appeal? It's an appeal that's happening while the case is happening. So instead of after a case, it's happening during the case. For all of you that are also saying the live chat's been a little weird today, I've noticed that too. It's not you. It's not just your YouTube. Live chat has been a little spotty today. I've noticed that as well. So the court came back from the break and the court had thought upon it. And the court said that all jurors appearing in person for questioning by the court and counsel is what's being requested by the defense. The court then said, defense has not cited any controlling or persuasive law that remote jury selection violates the Sixth Amendment. It probably doesn't. Under the standing order on all jury selection, under the standing order from the courts, all jury selection shall be performed by virtual means unless the parties show extraordinary circumstances. How, lawyers in Utah, how are you doing this? This is so strange to me. How are y'all doing remote jury selection? It seems so odd. You know what? I wonder if I practiced in a very large city. I wonder if in more remote counties that the amount of people actually appearing for jury selection, if they don't have to drive to court, goes up. Like, I wonder if this has increased participation versus people just not showing up. So I really do wonder if that has shifted. So the standing order from the Summit County presiding judge, is that all jury selection is remote unless there's extraordinary circumstances. The court then said there's technology that allows us to see the jurors. Technical issues can be treated like a failure to appear. And I was like, he's going to really deny this. And then he said, but what we can't do is expose the jurors to the conditions in the courtroom right now, and the environment cannot be replicated. And this court has now been persuaded that the extreme level of media attention requires exposing the jurors to that environment so their reaction can be judged in real time. So the judge granted that motion. I think it's the right call. But as he was going through, I was like, he's really going to deny this, isn't he? He really might. No. It's so wild. Kat, yes, I am actually very interested. It's just, look, I stopped doing trial work before COVID. So all the remote appearances and stuff, LA didn't do anything remote except for civil like call-in appearances. No Zoom court, no nothing. So it's all new to me. And I mean, I'm sure attorneys have learned to adapt. It's just, it's different. It's different. So the court granted that motion. So the veneer is going to be expanded for multiple counties, and the jurors are going to have to come and do voir dire in person. That will probably shift things a little bit. And so they are going to have to do that in person. So that takes us to the last motion. Let's recap where we're at real quick, and then we'll get into the last motion because I think we have most of that on video. Fingers crossed. So where we're at so far. At the beginning of the hearing for Kouri Richins, the prosecution moved to dismiss counts 3 and 4. Those are the distributions of narcotics count. Agree. It survived prelim. I think it muddies the waters. I don't think it makes the trial smooth. I don't think it's what the law intended. I agree. I was surprised they added it in the first place. It wasn't in the original information. We're going to get to the motion to consider bail next. Motion to expand the jury veneer to bring in jurors from multiple counties was stipulated between the defense and the prosecution. The court agreed. He said the mothership would permit it. The motion for in-person jury selection was also granted, though the court came into that motion, I think, inclined to dismiss and had to be persuaded. The court was like, this isn't a constitutional issue. This is how we do it. This is how we do it. The court's like, we've sorted this out. And both sides were like, we cannot do that in this case. And the court ultimately was persuaded. The defense made a motion to seat 12 jurors. The rule for non-capital cases in Utah is 8. The court denied that and said the law may change, but for now I'm denying it. I don't agree with the law, but I'm denying it. And on the motion to sever counts, the defense had a pretty good win on taking the mortgage fraud counts out of this trial. So the mortgage fraud counts and the subsequent forgery counts that go to the fraud are taken out. So Kouri Richins will face trial at the end of April, beginning of May on first-degree murder, attempted murder, and 2 counts of insurance fraud for getting a life insurance policy January 29th, 2022, ahead of the February 14th, 2022 attempted murder. Now we are going to shift gears and go back to, we're going to roll the tape. We're going to roll the tape back to the bail hearing, which I'm sure a lot of you already know the result of. Thank you for no spoilers in the chat. Let's see what the court does. But the bail hearing was most of what was reported on and most of what was televised. So we're going to go to that now. Let me get it queued up. Let me
I
know
was not concerned.
how the sound is. Again, this starts in the middle of the hearing. Why the video on this is so strange, I don't know. I don't know at all. But True said, wait, where did it go? True said, roll that beautiful bean footage. Yes. And then Chaos Wrangler said Park City at this point feels like a suburb of SLC. I mean, at least on Real Housewives it does. They take offense to that because they are bougie. I mean, that's kind of how Real Housewives of Salt Lake City feels, right? How my worlds would collide. I'm waiting for one of the Real Housewives of SLC to get called onto jury duty. How my worlds would collide, right? How my worlds would collide. All right, let us continue on. All right, I need to switch which screen I have shared. Emily, you just bring us behind the scenes on everything. Yep, we just talked through all of it. All right, and let's go back to court with Judge M. Is it Mazik? We're just gonna go with Judge Emily, you're fucking unhinged today. I know. I'm sick. I'm neurospicy. I can't even. Katie said, can you even imagine Lisa Barlow getting questioned? Lisa Barlow would roll in with like the largest like dirty Dr. Pepper from Wendy's that you've ever seen. Emily, they only do that at Sonic, not at Wendy's, whatever. She's a Wendy's girl. She would just be rolling in with a like 40-ounce styrofoam cup of soda, being like, oh my God, this is televised. Can we bring in Bravo cameras too? No way. Is she a liar? I don't know. Everybody calls me a liar. I don't really, Your Honor, I don't like it when people call anybody a liar. Like, Your Honor, triggered if they're going to call her a liar. Like, I can't. All right. No, chat. The judge's name is not Ronald. The judge's name is Richard. You know, as Peter Mon would say, thank God my name isn't Richard, because if it is, my code would be Dick. Let's continue.
I was not concerned that Ms. Richins was a flight risk.
Okay, this is going to the bail hearing. Sparkling rutabaga. That took me a moment. I am going to come back to the conversation about dirty soda at the end. She likes Diet Coke. She does. I'm going to come back to dirty soda later. There's a whole, we're going to go to a whole Utah rabbit hole if we get into dirty soda now. We'll come back. We're not getting into soaking though. Don't even ask. We're just going to court. There was a meme about it yesterday. Anyway.
Because of her connections
Maybe
to the
we
community through her business and her family, and because her kids were here.
All right. The judge is starting again in the middle saying previously, let me see if I can gain this up just a little bit. Previously, I was not worried about flight because, and he's talking about what he was concerned about previously. This is further into the proceedings. The defense has already argued about bail. Let me go to where the defense, I have notes. I'm going to pull up my notes about, where did they go? Where did my notes go? When the defense was arguing about bail, let's see. The defense main argument was, because it seems like we're jumping in the middle. The defense main argument about bail was that there was a change of circumstances, so the judge is allowed to consider or reconsider bail. You can't just ask for a reconsideration of bail all the time. You have to have a reason. And they said because at the first bail hearing, this was still a capital case, the circumstances have changed. The judge said, yes, I agree. There's a change of circumstances. It is proper now to reconsider this. It has to be, ripe for consideration. So there is a change of circumstances. It's proper to consider it. The court said, yes, in June 2023, the penalty was as severe as death, but no less than 25 to life. The court said, but now she is facing 25 to life on 2 counts, and that can run concurrent or just life, period, which is really an LWOP. The court continues and then juxtaposes the differences between the circumstance in 2023 and the circumstance now. The defense argued, look, she's not going to abandon her relationship with her sons. She has been in custody longer than anticipated. There's been significant delay in the case. There wasn't even a preliminary hearing until this new counsel came into the case. She's been in jail 17 months. Now there's been a preliminary hearing. The court has a better idea about the weight of the evidence. The court can look at the weight of the evidence. The defense argued this is a completely circumstantial case, and the court should look at that when considering letting her out. She said, then what is extremely disturbing here, and I don't think this is going to be in this part of the footage that we have, but I hope it is. She said what's extremely disturbing here is that we submitted to the court certificates about her progress in jail, and the state said that those certificates were beneath this proceeding. She said the state has no concept about what it's like to sit in a cement box, and to mock the defendant here in their filings is inappropriate. The court interrupted and said, counsel, you're not speaking to me right now. It seems that you're speaking to the media. And then she continued going on about the certificates that that Kouri Richins had earned while in jail. If you want to go through all of the certificates that she has earned, I have those motions. We can do that after. We'll let you know, or you'll let me know. And the court said, yes, but in Utah code, and then started going through the code, that an individual shall be admitted to bail as a matter of right, except when a person is charged with a felony and the court finds clear and convincing evidence that the person would be a danger after considering, and then he reads the entire section. So I think we're jumping into the court interjecting in the middle of the defense's argument here. So let us continue.
Not concerned that Ms. Richins was a flight risk because of her connections to the community through her business and her family, and because her kids were here. Her relationship with her kids has been negatively impacted, to say the least, in the intervening time. Structurally, she just doesn't have the same connections to the community that she had
just
then.
what it is.
Well, I will tell you, Your Honor, as a mother, that there is no way Kouri Richins is leaving her children, no matter what they're being told, no matter what their situation is. She will never leave her children's side under any circumstances, even to her own personal grave detriment. She has still extended family in this community.
Which, if I was the court, that she will never leave her children, even to her own grave detriment. If I was the court, that would concern me, because her children have been placed by the juvenile court with the victim's family, with Eric Richins' sisters, who this defendant had physical confrontations with and was actually charged with that. So my concern would be that there could be more confrontations between the victim's family and the defendant if she's out. That would concern me greatly if I was the judge.
She doesn't have the wherewithal to resettle somewhere else. She's lost everything. And, you know, she literally has no resources to leave the country to resettle in another place. She would have no ability to even support herself. The release plan that we presented to the court involves her living with family who would have to provide her with a home and food. And I mean, she of course wants to get a job immediately and work. But I will tell you that as far as her connections to the community, the most important connection is the one with her sons. And she will never, ever, ever abandon her sons. Even if it means she spends the rest of her life in prison. She's not going to do that. So I do think that as far as I wouldn't think that the court's previous finding that she's a flight risk should change. That she wasn't a flight risk. I'm sorry. I don't believe there's anything that's happened that should change that. I do think there are significant developments in terms of danger that the court can consider, which is the absence of the death penalty, the dropping of some of the drug charges, the fact that, you know, she has been in there a lot longer, I think, than anybody thought back in June of 2023 that she would be there.
We're not as far along as I thought. Oh, good. We're going to get to see the judge be spicy.
The withdrawal of her counsel, which is through no fault of hers, which is required under the statute, did cause significant delay to allow new counsel time to
How much was that actual delay?
Well, I mean, when we got in the case, there was no prelim. There wasn't even a prelim set because
it was a false start.
Right. So we had to immediately set a prelim. I think we tried to set one as fast as we humanly could. I think we did a good job doing that. So we set the quickest prelim we could, and then the hardest part, as Your Honor will remember, was trying to find a date where the court, all the parties, everyone could be available. Again, none of that's through any fault of the defendant or the state, frankly. But it's just because of the nature of the beast. She's been in jail now, presumed innocent, for over 17 months. She's looking at an additional, 6 months till trial? And, obviously if there's a second trial, that would be, another 6 months. If there's an appeal, that would be longer. Obviously, that would be a different circumstance. But all of that is not, through any fault of the defendant. It's just the nature of everybody doing the best they can. But that's just the reality that we have a woman presumed innocent being held in jail for an extended period of time.
It happens.
We also have had the benefit of a preliminary hearing, and the court is aware this is a circumstantial evidence case, and the facts of this case came much more into focus at the prelim, and there is, one of the things the court can consider when deciding bail is the weight of the evidence. Not, you of course presume the defendant to be innocent, but you can look at weight, and we have new evidence now as to what weight will be. And then finally, Your Honor, I would like to take a moment to address
She's mad.
what I found to be extremely disturbing, which is we submitted to the court some certificates, letters from people in the jail
He's blinking
of
a
the
lot more
positive
now.
programming that Ms. Richins has been involved in. And when I read what the state said, that presenting those was beneath this proceeding, I would like to address that.
I don't think you need to go too deep into it. I commend Ms. Richins for using her time in custody as productively as possible.
I find it very disturbing that an office whose job it is to put people in jail has such a lack of concept about what it means to sit in a jail cell in a cement box, isolated from everyone and everything you love for 17 months, being presumed innocent, and mock trying to do better, trying to engage with the jail community.
Ms. Nestor, with respect, I don't feel like you're talking to me so much right now as you
I'm
are
not.
talking to the public and to the Summit County Attorney's Office.
I am, and I think it needs to be heard. And I think, I could not be
He's like,
prouder of
"Stop now."
Kouri
She's like,
Richins for the
"Nope."
way she's conducted herself under the most horrifying circumstances imaginable. And I honor the volunteer.
I was a prosecutor for a long time. So when she's arguing the most horrifying circumstances imaginable, I think of what she's accused of first and how horrifying it would be to have your spouse poison you, you survive, and then they try to figure out how to give it a go again and then leave you to die. So I think sometimes these arguments, and they are being zealous advocates for their clients, get a little lost on me in light of what she is accused of. And yes, she is presumed innocent. We saw what evidence will likely come out at trial. There are quite a lot of text messages. So when we're talking about horrifying circumstances, there are some arguments that are less well taken from me.
Volunteers that come and do those programs and that spend their time and their energy, and they do it. I don't even think a lot of them get paid. I think they do it because they're good people and they care about people sitting in the jail not losing their minds. And so when they filed that answer, I wasn't going to file all the certificates she did, but when I saw their answer, I supplemented and filed them all. Because I think each and every hour she spent engaging with her community, trying to focus on positivity, to learn, to better herself, is something this court can and should consider. And not only is it not beneath these proceedings, it is what our proceedings should be about.
I understand.
And so based
like,
on
yeah,
all of those reasons, I
get
will
it.
say, you know, we have a situation where I believe the amount of discovery we have in this
The judge is
case
like, "Are you done?"
is now up over, Alex, what, more than 2 terabytes?
Easily, yeah.
Easily over 2 terabytes of discovery. We have hundreds of interviews, hundreds of thousands of documents. When Ms. Richins is detained, the ability to review and go over that material with her to help her prepare for trial is almost near impossible for us as a defense team. She is a critical part of her defense. She is a very bright, engaged, curious woman who wants to know everything that's going on with her case, as she has a right to. We have to, the jail is so accommodating to us, and they make this room available, but it is a room with glass between us.
Yep.
There is no way for us to share documents, to review, to look at videos. And point of personal privilege, there's a little metal stool that I have to sit on for hours and hours and hours to try to go over thousands of documents with my client, and it
Yeah, that
definitely
sucks.
puts us at a horrible disadvantage. There are conditions that this court could impose
Your Honor,
on Ms. Richins,
my back.
including ankle monitor.
Honestly, I would be mad too, but that's what this attorney does for every client that she has in custody. I would gather that probably the majority of her clients are in custody, but like, I get it. That would also suck, but also that's what it is. So she's like, Your Honor, it would just be so much easier if we could just have Kouri come to our office and prep the trial there. This is exactly what Diddy's arguing on his latest bail motion. It's not an uncommon argument. Your Honor, we can't adequately prepare for trial without free and unfettered access to our client. So
GPS, house arrest, where she does not leave the home, period, for any reason, where I could go to a place and share with her the documents at a kitchen table, and we could actually prepare for this trial and have a fair shot.
and an egg sandwich.
There
I'm not letting
are
it go.
conditions you could put on terms of social media. There are limits you could put on, you could put a gag order on her. You could prohibit her from contacting
Did you see
any
the judge be like, "I'm not gonna
any
help."
witnesses, period, at
Remember, Kouri's already done interviews from in custody. I went over those too. Like, you can put a gag order on, and the judge is like, "What? She's already talking to the media from in custody. What?
all, full stop. You could require her to check in with probation, do constant drug testing, not that that's an issue in this case, but whatever the court felt the court needed to do to allow her a situation where she can prepare for trial and not be a danger. The release plan that we have provided to this court would provide for her residing in Salt Lake County. So the chance encounter of witnesses would go down significantly. There are very few witnesses in Salt Lake County in this case. Almost all are in Summit County. She would have the opportunity to have supervised visitation with her sons, which we discussed earlier. I'm not going to get into that. But in terms of she would be able to work, she would be able to, we could make certain that she's brought to and from court. We could, any conditions the courts wants. I think the behavior that she has displayed throughout the time that she's been incarcerated shows that she's always complied with the orders of this court and would continue to do so. And we are asking that the court take this very, very seriously. It just can't be overstated the disadvantage we are at when we cannot review the case materials with our client in a functional way. And we would ask that the court take that into consideration. Furthermore, I read the state's response to our motion for bail, and it was almost, I believe they referred to her motive and to her character. And that's not before this court. The court's got to presume that she's innocent of this crime, and you know that, and I know that, and they know that. And why they did a brief that referred to her as someone being parasitic, which, by the way, I don't know if that just means because she's a woman and she's parasitic to her husband. I don't know why that phrase was used, but it's improper and it's inappropriate, and it has nothing to do with the bail determination.
I need to know. We're gonna have to go find why the state called Kouri Richins parasitic, aren't we? We're gonna need to do that, aren't we? All right, we're gonna do the motions after we do this. I think. Do we have time? I think we have time. We have time, right? Chat. We have time. I have time. It's gonna be good.
We're gonna do. We're asking that this court consider taking the step to allow her under the strictest conditions that make you as comfortable as possible, so that we can work with our client and get ready for trial. And we do think clearly we've met a material change in circumstances sufficient to reconsider. And as we stated in our brief, the fact that she no longer is facing a potential death penalty means she has a constitutional right to bail. I know you know that, but of course it is
before too.
You actually ruled that way before, which was honorable.
Not so much that she had the right, but she had the option to request, and I had the authority to consider it.
And the case that came down after the detention hearing, oh my gosh, I just had
Barnett.
Thank you. The Barnett case also makes clear that even if you find that there's substantial evidence, and even if you find there's a risk of danger to the community, you still have the discretion to make the determination. And I believe you opined that you thought that before the Barnett case came down, and you were absolutely right. And the Barnett case reassured that that is in fact the state of the law, that you have ultimate discretion, and we are asking for the court's mercy and for the court's ability to work with our client. Thank you, Your Honor.
Thank you. Mr. Bloodworth, I read the state's brief. I think I understand your position clearly. Anything to add?
No, sir, thank you.
Could the judge signal any stronger that he was not persuaded? Mr. Bloodworth, I read your brief, and I think I understand the state's argument. Look, sometimes when the judge signals that that you don't need to be heard from, it's okay to just sit down. And Mr. Bloodworth is like, yep, 10-4, sitting down now.
All right. Under Utah Code 77.
Let me see if I can gain this down, because he's talking directly into the mic.
Subsection 1, an individual charged with a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony when there is substantial evidence to support the charge and the court finds by clear and convincing evidence that,
fairly low standard.
1, the individual would constitute a substantial danger to any other individual or to the community after considering available conditions of release that the court may impose if the individual is released on bail, or 2, the individual is likely to flee the jurisdiction of the court if the individual is released on bail. These provisions mirror
The court's reading from his prep. So judges can change their mind after oral argument. We saw that happen in this instance. I think the court was ready to deny the in-person voir dire and then changed his mind. But The court's gone through all of these motions, and the court has prepped the law on the motions, which is what he's looking at now. And the court has prepped what the law says, and then a tentative. And sometimes the judge will just rule that tentative, and sometimes the judge won't. But when we see judges ruling from the bench like this, it's because they are incredibly prepared. The oral arguments often don't change much of what's on the motions. Sometimes they do. It's more rare. So the court hears the argument and is ready to rule, which is different than some of the other jurisdictions where everything is taken under submission all of the time. This judge is like, no, we're ruling from the bench. Let's go. You guys need to know. I need to know. We're ruling today. We're moving on. And then these will all be issued as minute orders or written orders down the road. But then the attorneys at least know as they're moving forward what they're doing. So it moves the case along a little bit more smoothly.
Article 1, Section 8 of the Utah Constitution,
Like Judge
which
K,
provides that all persons charged with a crime shall be bailable except persons charged with any other crime designated by statute as one for which bail may be denied if there is substantial evidence to support the charge and the court finds by clear and convincing evidence that the person would constitute a substantial danger to any other person or to the community or is likely to flee the jurisdiction of the court if released on bail. The court made that determination in June 2023 and found, one, that the aggravated murder charge was supported by substantial evidence, and two, that although the court was not concerned that Ms. Richins would flee the jurisdiction, given her structural ties to the community and to her children, which were in the community, that the court was nonetheless persuaded by clear and convincing evidence that she would constitute a substantial danger to herself and to the community if released on bail, and that that danger could not be mitigated by reasonably available conditions of release. Which brings us to today. Pursuant to her motion to reconsider bail and conditions of release, Ms. Richins argues that in the intervening time, there has been a material change in circumstances. That is the state's decision to decline seeking the death penalty. I agree that that is a material change in circumstances that allows the court under 77-20-207 subsection 1 to revisit the issue of bail and pretrial release.
So yes,
Defendant does not challenge
the
the court's determination that the aggravated murder charge is supported by substantial evidence. Rather, defendant asserts that upon reflection of the status quo and the intervening events, that Ms. Richins is not likely to flee the jurisdiction if she's released on bail and no longer constitutes a substantial danger to the community given available conditions of release. Ultimately, the court is not persuaded.
We could see that coming.
While defendant no longer faces the risk of the death penalty, she now faces 2 first-degree felonies, each with a minimum sentence of 25 years to life, in which may be run consecutively, one
Meaning
after
50.
the other.
Right.
As before, the severity of these sanctions, put plainly, of potentially dying in prison, creates a powerful incentive for defendant to harm herself or witnesses in this case, and to flee the jurisdiction of the court. And as before, substantial evidence supports the charge that defendant secured fentanyl and deployed it to kill another person, which is inherently dangerous conduct.
Right.
Moreover, defendant's relationship to her children and her ongoing real estate businesses were, in June 2023, substantial connections to the local community that mitigated the risk that she would flee. But now, in November of 2024, those anchors have been weakened substantially.
Yeah, things have changed.
The juvenile court
Her
has
business.
granted guardianship of
And this is how we knew for sure. It had been reported that her kids were with her in-laws, but the court put it on the record here so we know for sure what the juvenile court did. I did that badly.
Ms. Richins' children to members of Eric Richins' family, and through that guardianship, they are limiting Ms. Richins' contact with her children. And that circumstance is likely
Sorry, I didn't realize captions had gotten turned off.
persist in some
Thanks, Chad.
form, even if Ms. Richins is released on bail. And there's a reasonable inference based on the evidence admitted at the preliminary hearing that defendant's real estate business is now defunct and that she would not be able to restart it at any time in the near future given the cloud
Counsel takes notes like me, and I appreciate it.
constituted by this case. So as compared to June 2023, the current circumstances support a finding by clear and convincing evidence that defendant poses a substantial danger to the community and that defendant is likely to flee the jurisdiction if released on bail. Moreover, the court is not persuaded that there are reasonably available conditions of relief,
Yay, back to the job.
release to mitigate those two risks. True, GPS-enabled ankle monitoring is available, but any report from those monitors comes days after the fact.
Which is a problem.
We have, with some regularity, seen defendants just cut them off and flee, and we don't know about it until days later. They are
CEG, Fat
not
Leonard.
as protective as we would like.
Right.
Living with family in Salt Lake offers Ms. Richins a place to go, and without impugning her family at all, they're not law enforcement officers, they're not probation officers. It's not reasonable to expect or require them to supervise her 24 hours a day. Given the extreme consequences that this case poses,
I told you guys, he has a way that he says extreme when he was talking about the media. Oh, Your Honor, that's a really rude pause. I'm so sorry. Hold on.
and
All right, that's not much better. Hold on. Can you? Apologies for the pause face. I told you when he was talking about the media earlier, when he talked about the extreme media attention, it's one of those words that he has a particular manner. It's not just extreme, it's extreme. Even the word extreme becomes extreme. And I think it's hilarious. But every time the judge said extreme media attention, it was extreme media attention. Anyway, I thought it was hilarious. So I'm glad we got to catch one of them on the record since we don't have the video of the entire hearing.
given the extreme consequences that this case poses and the severe negative impacts that this case has had upon Ms. Richins' business and her relationship to her children. The court finds by clear and convincing evidence that there simply are not reasonably available means of mitigating her risk to the community and to herself,
Right.
or the strong incentive for her to flee the jurisdiction of the court.
He's like, yep, nope.
Defendant's motion to reconsider bail and conditions of release, docket 653, is respectfully denied. Ms. Nestor, anything further?
Denied.
No, Your Honor.
Mr. Bloodworth?
No, sir.
Okay. That brings us to the end of motions for today. I don't think we have another motions hearing on the calendar, but do we want to
And
put
now
one
we're going to
on?
get into the scheduling.
Yes, sir.
I'm going to let them argue over scheduling because I think as they talk about scheduling, we get a little bit of insight as to what they want to do next. But this is the end of the motions hearing. So we got the beginning of the day and the end of the day. We are missing the middle bit. If I ever get the middle bit, we will go over it. Even though we know what the judge rules, we'll still go over it. Because again, it was a summary. And I think in a case where we're going to be covering the trial, it's interesting. Some of the cases I jump in right at trial. Some of the cases we jump in right at the beginning of the case, just depending on the case and bandwidth of what else I'm covering. And this case was, again, from the bail hearing, wild. So I I'm just fascinated. And then the walk the dog letter, I'm like, oh, tell me everything about this case. I'm so in. We're covering everything that happens. So let's go through the scheduling, and then we will pull up those motions to see where that parasitic language comes from and to see all of the certificates that the defense put into evidence, and go through a little of the back and forth between the defense and the prosecution before we wrap up for the day.
I know as trial approaches, there's likely to be any number of motions in limine, but we're going to have to make some decisions well in advance of the last week of April about how we're going to conduct jury selection, what the jury questionnaire is going to look like. When do you want to start talking about those things? Even just a pretrial conference to start sounding them out seems to be a good idea.
That's a good question.
Shortly after the holidays?
Probably. Which holidays, I guess.
Thanksgiving or Christmas?
Shortly after Christmas. I imagine we all have plenty to do between now and then, but if you need, I'll make room, Ms. Richins. I recognize you're in custody. I'll push stuff off my calendar.
Right. The
if you
court's
need a
like, if
hearing
we need
before.
to hear something sooner, we'll hear it sooner.
Your Honor, could we
Mr.
communicate
Bloodworth
with
is just like,
some-
Your Honor, this is the busiest time of year in court. Can we please? This is between now and Thanksgiving. Between like really November 1st to Thanksgiving week is crushed in court. It is incredibly busy. Everyone's trying to get everything done. And then from like December 5th to like December 15th, there's one more crush of like trying to set dates for the new year. And then everything comes to a screeching halt. So this is a super busy season running up to nobody being available to be in court and nobody wanting to be in court, nobody wanting to run trials. Jurors don't want to come in. Courts are generally only closed on Christmas Day and Thanksgiving Day and then the day after Thanksgiving. So most courts are closed Thanksgiving Day, the Friday after Thanksgiving, and Christmas Day and New Year's Day, and that is it. But nobody wants to be there. Judges take time off, so courtrooms are dark. Oftentimes a courthouse will have one or two courtrooms open that's running arraignments and warrants, and that's about it. So the court system does come to a bit of a halt the week of Thanksgiving, and then the weeks between like the 20th, 22nd, and January 3rd, 4th, 5th, depending on where the holidays fall. Jurors don't want to be there. You try to bring a juror in over Christmas, they're just like, miss me. Life is busy, things are busy, and all of it. So
the county and our team, and
that's why they're trying to find dates.
maybe communicate via email with the court on a good date that we might, or a range of dates. I do think
can
getting
we
a new
pick a date to pick a date?
We are
about
going to have
picking a date?
motions that relate to admissibility and suppression and that good stuff. That's the next round. So
That's fine. It doesn't have to be the next round.
right.
Can we pick a date about picking a date?
So I just feel like getting a hearing set in January is probably a good idea.
Okay.
Your Honor, as the state has done throughout, we will accommodate whatever scheduling the defense wants. Our preference, however, is to schedule it today. We've found that, you know, if we leave your courtroom and promise to come back with dates, that lingers. So
Your Honor, picking dates over
we would
email
like to
sucks.
schedule
We just
at
do it
least
now.
the next round of motion practice. Defense has referenced some very specific motions in limine. I think we can at least set those.
Can we just pick days?
And we're just not ready to do it yet. We're going to have to get back to you on some dates, Your Honor.
Okay, but we need a date.
I mean, but we've got to, we have, both Ms. Lewis and I have trial matters pending.
May I offer a different suggestion?
Yeah.
Can we schedule a brief pretrial conference, say in about 4 weeks, to then come up with a schedule for figuring out how to get from here to trial?
Yeah.
Okay.
Yes, sir.
And it's always yes, never yeah. And she's like, yeah, wait, no, yeah, yes.
So that's December.
Would you please look at the week of December 9?
So they're
Could
going to pick a
I
date.
persuade you to have a hearing on the morning of December 12th.
They're going to pick a date to pick more dates. I love that the video just ends with, first of all, the end card. I love that the end card pushes to the video that we're doing. And Peter, hey Peter, but the video pushes to the end card of what we're doing. And you can tell what I was watching earlier. Was I watching the Cornell Feeder Watch? Yes, I was. But the court did pick a date on December 12th. The date on December 12th is a pretrial scheduling hearing. So they're all going to come back to court to schedule out what it looks like, as the court said, what it looks like to get from here to trial. Trial's supposed to start at the end of April. So there will be scheduling for 702s to go through the process of jury selection, to talk about the motions in limine. So that will be on December 12th. If there is any footage of that, we will go through it, but it's generally just going to be, hey, these are all the next dates. It's not going to be a ton of actual things happening in court, but there will probably be motions filed between then and now, and we'll go through those motions filed. Speaking of going through motions filed, should we just, I put up the poll and you guys are like, all right, let's see it. So 80% of you were like, yep, let's go ahead and see the documents. So we're going to go to those motions. Even though we know the ruling, I think seeing how we got here is sometimes helpful. So let me pull up the defense motions first, and then we'll see if we can figure out why the prosecution used the word parasitic, which really pissed off the defense quite a lot, didn't it? So let me see where my Kouri Richins notes are so I can pull that motion. Come here. I'm working off of 4 documents right now. So the document for the hearing and then the document that has all the documents. So that was in the motion to reconsider bail. Let's pull that up and go to the motion to reconsider bail. All right. And then we're working on 3 different screens. So it's, I can't wait. No, that's the wrong thing. I can't wait till I live in the world of like being able to just go like this and just like throw things around like Iron Man. I'm waiting for that. There are parts of technology I'm very excited for. That is one of them. And being able to throw things back and forth, I'm very excited about. All right. We're going to go through the defense motion part 1, and then we'll go to the defense motion part 2, because once the prosecution pissed off the defense, they filed a whole bunch more certificates. So now we're going to see all of them. So the defense is like, fuck you. I'm mad. I want you to see all of them. All right, let's see. This is the motion to reconsider bail. That's exactly what we need. Let's pull that up. And Terry, I went through the walk the dog letter when it came out, so I have coverage of it. There's a whole playlist on this case. I don't know if it's still on the docket or if they took it down. There was much argument over it, and I don't remember what the end result was, but I covered it when it was out. So we did a dramatic reading of the walk the dog letter. So yes, we did. All right, defendant's motion to reconsider bail. We heard on May 8th, 2023, Kouri Richins was charged by information with multiple felony offenses, including a capital felony, aggravated murder. Ms. Richins was taken into custody, held without bail on May 15th. Kouri Richins, with original counsel, filed a motion to consider the right to bail. On June 9th, 2023, Richins filed a motion to set conditions. Also on June 9th, the state filed a bench brief seeking detention, and then they did a hearing with testimony. I covered that. That was on June 12th, 2023. Material changes in circumstance. This is no longer a capital case. The court said that was a material change in circumstance. Let's see. They're arguing the constitutionality of bail. Oh, are there other changes of circumstance? Let's see. While Ms. Richins has been incarcerated, her relationship with her sons is being irreparably damaged. I don't think the custody is the all of that, but y'all let me know in the chat what you think. The Richins family is refusing to allow her access to her sons either through visits or calls. Is anyone surprised by that? Her letters and cards go unanswered, and there is no indication her sons are receiving her communications. Ms. Richins' sons have been told she is no longer their mother. Well, how do you know that? and they should only think of her as a distant relative. I don't know how they know that. I'm curious. After 4 months of not being allowed to speak to her sons at all, only after a court order did the Richins family finally allow a video visit, during which the boys were told to say hello, goodbye at the end of the call end the call after 2 seconds. It goes on to say the forced separation and emotional estrangement from her children is causing Richins extreme emotional distress during a time that she is presumed to be innocent under the law. If she were to be released, she could participate in supervised in-person visits and try to repair some of the damage that has been done to her relationship with her sons before it is too late. I don't know if that would happen. So let's see. The trial is now set for the end of April and May 2025. At the time of the original detention hearing in June 2023, it was believed that a preliminary hearing and trial were imminent. Okay. And then they attach all of her, let's see. They attach their transcript because they are arguing that the prosecutors improperly argued at the end of the, let's see, is this at the end of the detention hearing? Oh, now I have to go find where they cited this. Hold on. Sorry, y'all. Let's see. Where did they talk about the transcript? I don't see where they talked about it. Let's see. They said that she could live with family. We heard all those arguments. It's all right. They included the transcript. We're not going to go through it. The issue before the court is whether defendant Kouri Richins should continue to be held without bail during the pretrial period. The court determined that. We went through it. We watched the entire bail hearing together. It's on the playlist. So we're not going to go through the entire transcript of that. These are the certificates, which is what I wanted to go through. So certificate number 1 is a certificate of participation in the following 5 classes: seed starting, woody plants. If there has ever been an opportunity for an EDB collab with Epic Gardening, I didn't think the door would ever be opened. I didn't think we'd ever have an open door for me to get to talk about Epic Gardening, but now is the time. Now is the time. We could talk about seed starting. He could tell me what the fuck woody plants are, because I have no idea. What integrated pest management looks like. We could talk about, I don't even know how to pronounce herbaceous plants and weed control. I'm ready. I am ready. Kevin, Kevin, we need you. Tell me what woody plants are. I don't know. Am I a good gardener? No. Do I love a house plant? Yes. Do I love houseplants when I don't have orange cats? Yes. The orange ones are feisty. But I see opportunity. I see opportunities and weed control. Maybe the feds will stop the weed control and we can all just stop fighting over ridiculousness, but that's me. Certificate of Completion, Intro to Arts. The certificate is awarded to Kouri Richins for completing a course of art methods. Look, I don't disagree that there should be things to do in custody. I think that it is better for humans. I think having something to occupy your time is healthy. I think having time to complete art and gardening is a good outlet. Most of these programs are volunteer run. I think it is work that needs to be done. Do I think it qualifies her for bail? No. Do I think it should be offered in custody? Yes, I do. And I think that that's okay. Do I think it qualifies her for bail? No. Personal Education Foundation recognizes excellent achievement of Kouri Richins in the course of faith-based parenting. This course includes written response to the book Grace-Based Parenting. I don't know if that's well taken for the prosecution. Certificate of Excellence. I really hate that these are all sideways. Certificate of Excellence in Raising Relational Kids in a Screen-Driven World. based on the book. So it's a book club based on the book Growing Up Social, Raising Relational Kids in a Screen-Driven World. Okay. Kouri Richins for the successful completion. That might help. Oh, no, too far, Emily. You've gone too far. Oh, well. Let's see. The completion of a 6-month course in American history and the Constitution. Okay, good. Constitution. Good. Learn the Constitution. Sure. This is to the judge from the director of SCRF that says, I write to verify the enrollment of Ms. Richins in the Adams State Prison College program's paralegal studies course. Is anyone surprised? Is anyone surprised? Is anyone surprised that she is wanting to become a paralegal, offered in concert with Barbary? I didn't know Barbary offered classes in custody. I just remember how expensive it was to take the Barbary bar prep classes. I wonder how expensive those are now. Richins enrolled in August and continues to be a student in good standing. Oh my God. Are we going to see her stand up at trial and fire her lawyer? It's never going to happen. But could you imagine? She's going to be like, Your Honor, I have a motion for Crest White strips. As an aside, Ms. Richins is resolute in her work, very positive in her interactions, and appreciative of support lent to her learning. I mean, I don't doubt that. For those of you asking what Barbary is a private company that does bar study prep courses, and apparently a paralegal course and other things. So it is a company that provides practice tests and studies and stuff. You can do in-person, or you could do in-person and not in-person Barbaries. And I'm sure they have other courses as well. And the chat is saying they have computer-based paralegal courses. Great. Congratulations. You've been accepted to CCU. Dear Kouri, I'm pleased to inform you that your academic evaluation is complete and you've been accepted for admissions in our Masters of Business Administration in Management. Congratulations. What date is this? October 9th, 2024. So she's also getting a master's in business administration. For your convenience, your enrollment agreement has been sent to you via Write signature. If you did not receive it by the end of business, please check. There's an educational plan, a W-9, a credit card authorization for the registration fee. I wonder if her family is paying the registration fee. Please review all documents. We look forward to helping you reach your educational goals from California Coast University. And those are the initial certificates. Then the prosecution said something that pissed off the defense, and they filed a bunch more certificates. So I'm going to go to the bunch more certificates, and then we'll get to what pissed off the defense. So let's go to docket. What is this? 691. And see, because they said they weren't going to file them all, and then the prosecution made them mad, and then they're like, send it. Let's see what made them mad. Let's see what made them mad, shall we? All right. Defendant supplemental exhibits to motion to reconsider bail and conditions. Comes now defendant Kouri Richins by through counsel of record and respectfully submits for this honorable court's consideration Exhibit 5 as supplemental exhibits of her motion to reconsider bail. Oh, there was no snark. Where's the rage? This is from November 7th. Exhibit 5, Part 1. There are 39 pages. Why are these blank? Okay, whatever. Let's see. Fit to recover. This letter is for Kouri Darden. Oh, she's not using Richins in custody? All right, well, the docket has her as Richins Darden. This letter is for Kouri. She has attended a minimum of 15 Fit to Recover classes. She has shown consistency every week and has had a willing attitude. Fit to Recover is a community that helps people in sobriety and mental health connect with one another and seek balance in their lives through our core foundation of fitness, nutrition, community service, and creative arts. Okay. Part 2. Why are there so many blank pages? Are those redacted? I wonder if some of these are redacted. Interesting. Part 3. Part 4. Also, why are these all blank? That's annoying. Are they all redacted? Is it really all redacted? Oh, that's annoying. Emily, you should preview things before you pull them up. No, then we don't get the genuine first look. Genuine first look, most of that stuff is redacted. So I don't know what certificates they are other than the mental health and sobriety. Okay. Kouri is staying active, which is probably good for her mental health. However, that doesn't necessarily qualify her for bail. Let's see how the prosecution pissed off the defense then, because now I'm curious. And that was a big nothing burger. Unless they just didn't download properly for me, it seems like a lot of those are redacted, which is disappointing, but other certificates, I guess. Maybe they don't want everyone to know, but she's going through a paralegal course. She's getting a master's degree. She's working out and she's doing parenting classes. Okay. All right. State's opposition to the defendant's motion to reconsider bail and conditions of release. I forgot to swoop. I didn't get to swoop much today, so send it. This is from the prosecution. Mr. Bloodworth says, the court has found substantial evidence supports that the defendant committed aggravated murder by poisoning for pecuniary gain. Excuse me. And the for pecuniary gain can be a special circumstance. We saw that in the Menendez case. It was one of the special circumstances that made that case a capital case. Poisoning involves cold, calculated planning and implicates a level of risk and lethality exceptionally higher than crimes of passion. Pecuniary gain implicates a thirst that cannot be quenched. Counsel? Are you creeping on the chat? Counsel. I feel like Mr. Bloodworth is a law nerd. Chat, do we think Mr. Bloodworth's a law nerd? The thirst that cannot be quenched is chat. Okay. You've read the room accurately, counsel. Oh. Leslie asked what happened to the Menendez retrial. I've been covering the Menendez case more consistently on QuickBits. So if you get the Monday episodes on the audio, your favorite podcasting app on Monday, or on the QuickBits channel, my QuickBits channel on Monday, I've been keeping it up to date on the QuickBits because it really is, there's no deeper dive. There's just updates at the moment. So that's where I've been keeping. If you have the Law Nerd app, you get those notifications on Monday. If you don't, the QuickBits channel, those drop every Monday. And if you saw the podcast episode this week, everything's moving to the Monday show. So defendant poses a substantial danger to the community. Nothing has changed. Thirst that cannot be quenched. Mr. Bloodworth. We feel attacked. Preferred disposition and grounds. The state of Utah opposes the defendant's motion. The court found at a June 12th, 2023 detention hearing that substantial evidence supports the then capital aggravated murder charge, and further found by clear and convincing evidence the defendant poses a substantial danger to the community. Utah law circumscribes when a court may reconsider a pretrial status in order retrial status order to certain enumerated material changes in circumstance. So they're arguing there's no material change in circumstance, or it seems that they're maybe illustrating that. I think that there was a material change in circumstance because the penalties changed. So we're going to skip that. The court thought so too. They say the change in circumstance asserted in the motion are not material under this definition. Accordingly, the court should deny the motion as a matter of law, assuming arguendo that the motion's asserted changes in circumstances are material under Utah law. They are not factually supported nor correct. Accordingly, the court should deny the motion as a matter of fact. Statement of relevant facts. The state believes the existing record in this case. No mincing of words. It's in the record, Your Honor. You know. The state believes the existing record in this case contains sufficient evidence of the court to deny the motion to the extent that the court is unclear or unresolved regarding any of the facts the state relies upon herein. The state respectfully requests an evidentiary hearing. Your Honor, do we need to put the witnesses on again? The defendant relies exclusively upon the Utah Constitution. The defendant neither cites nor argues Utah Code 70-20-102-10 and the materiality factors. The authorities that the defendant relies upon support the proposition that this court had the discretion at the detention hearing to consider bail in the case. Indeed, the court at the detention hearing agreed. The court then exercised its discretion, declined to grant bail, and ordered the defendant detained without bail pending trial. The instant issue, of course, as to whether the defendant may move the court to modify its pretrial status order. Yes, that's the issue at hand. The relevant legal authority that the state identifies above and addresses below establishes the defendant lacks a legal basis to move the court to modify its order. The court said there was a change in circumstance, but still was disinclined to acquiesce to the defense request. The state declining to seek the death penalty is not a material change in circumstances. I don't know. I don't disagree with the court on this. It does change things quite a bit in a case, but she still is facing essentially life in prison, so it does change things. They say that the state declined to seek the death penalty because the court considered, I need to back up. Regardless, it's immaterial that the state declined to seek the death penalty because the court considered bail under the pre-convention bail statutes. Pre-convocation? Either way, bail statute, first-degree felony provision in addition to the capital provision. I understand their argument. So that the state is arguing, excuse me, the state is arguing that the court considered it as both a capital case and a non-capital case. And because the court did that previously, then it doesn't need to be readdressed now because the court considered it under both circumstances. So it's not a change of circumstance because the court considered it both ways. Fine. They say this change of circumstance is not material because of that. Assuming arguendo, the defendant's assertion is legally viable, it is factually incomplete to the point of inaccurate. Boop. The defendant asserts that the court's original ruling considered the possibility of a death penalty as a significant factor in why the defendant posed a substantial danger to the community. To be complete and accurate, the court's original ruling considered, quote, the possibilities of sentences as severe as the death penalty and no less severe than the indeterminate prison term of 25 to life. So because the defense stated in their motion that the court's determination was based largely on the death penalty, that's why we saw the court clarify this. The court actually said this exact quote in their ruling. The court said, no, I said the penalty was as severe as this, but also this. Because again, if it is a capital case, then a jury can determine the more severe or the less severe penalty. But both of those penalties are quite severe. The court also found the severity of those sanctions altogether contributed to the defendant's substantial danger in the community. When read fully and fairly, the Bloodworth just has a way with words. When read fully and fairly, the court's ruling regarding substantial danger to the community accounted for the possibility that the state would decline to seek the death penalty. Exposing the court to facts and argument that it did not know at the time of the detention hearing is not a material change in circumstances. Oh, this is probably where the arguments come in. So what she's been doing in court since is not, or what she's been doing in custody since is not really a circumstance to be considered. I say, Lulu, I say it all of the time. Artstea? No, that's probably not correct. Lulu. She has not been offered a plea deal. We've had no indication of a plea deal at all. Okay, let's keep going. The defendant asserts that this is a material change in circumstances, that the August 26, 27th preliminary hearing exposed the court to facts and argument that it did not know at the time of the detention hearing. The defendant further asserts that this purported change in circumstances relates to the court's finding that substantial evidence supports the then capital felony charge. This asserted change in circumstance, however, is not material within the code. It is inevitable that the preliminary hearing held after a detention hearing. I mean, that's always how it's going to be. Well, not always. I mean, not always. So, but I'm not going to delve into the circumstances where somebody can get held into custody after a preliminary hearing. It's often the case. Let's see. It is inevitable that a preliminary hearing held after a detention hearing will expose a court to facts and argument that it did not know at the time of detention. The legislature could have included holding the preliminary hearing in 772102's materiality definition and chose not to, presumably because the new facts and argument may be immaterial. Well, if a case is not held to answer, then nobody's held in custody. And if they are held to answer, that's higher than clear and convincing. So either way, it kind of sorts itself. So accordingly, they say exposing the court to facts and argument that it did not know at the time of the detention hearing does not provide the defendant with the statutory authority to seek a modification of the order. The defendant asserts that the court is now aware of facts that were unknown at the time of the detention hearing, specifically that the lead detective cannot testify with direct evidence about precisely how the fentanyl was administered to Eric Richins. I mean, it was found in his system, so it was in fact administered. So, and whether the pills defendant purchased from Carmen contained fentanyl. I mean, Carmen will say that they will, but was that scientifically tested? No, but is the autopsy determinative on this? Yes. Excuse me. The we know Emily's sick, so I apologize for all of the noises. First, that this assertion does not implicate facts, rather it implicates the absence of facts. Bloodworth. Mr. Bloodworth, since you are clearly a fan of the Law Nerds, instead of first, this assertion does not implicate facts, but rather implicates the absence of facts. Can you start those sentences with, well, actually? Just dive into the neurospiciness that all of us appreciate and just lean into the, well, actually, Your Honor, this assertion does not implicate facts. It implicates the absence of facts. Those are not the same. Just lean in. Just lean in. Just lean in. You know you want to. Nonetheless, of this improper argument, the discovery that the defendant possessed at the time of the detention hearing and the state's presentation at the detention hearing made known that the state did not resolve these questions with direct evidence. The court, however, found the state's circumstantial evidence sufficiently resolved these questions to find that substantial evidence supports the aggravated murder charge. And they found that at prelim too. Nothing has changed. To the extent that the defendant's assertion is a consideration, it is not material. Regardless, any lack of direct evidence, and you hear jury instructions on this all the time, direct evidence and circumstantial evidence are entitled to the same weight. So, let's see. The state presented an extraordinary amount of circumstantial evidence at the detention hearing that showed that the defendant poisoned Eric Richins using fentanyl that she had purchased from Miss Lauber to include toxicology results, cell phone data, internet search history, insurance records or life insurance records, financial information, and the defendant's own admissions. Defense counsel's argument of any sort, of course, is not evidence that the court can consider. Positive jail behavior is not a material change in circumstances. So they're still arguing that there's no change of circumstances. The court found that the shift in punishment is a change of circumstances, but nevertheless, he can consider the bail, and he considered it and denied it. Let's see. The defendant asserts that her, quote, pattern of positive behavior in jail is a material change in circumstance. The defendant further asserts that this purported change in circumstance relates to the court's finding that no release conditions can adequately protect the community from the substantial danger she poses. The defendant does not assert that this change in circumstances relates to the court's finding that substantial evidence supports the then capital aggravated murder charge. Accordingly, even if the court reversed its finding that the defendant is not a good candidate for supervision in the community, the court's finding that substantial evidence supports the then capital aggravated murder charge remains unchallenged and undisturbed, and the pretrial status order remains viable. We need more water. Regardless, it is immaterial within the context of protecting the community from the substantial danger that the defendant poses that she has displayed no indications of violence or danger, or completed multiple classes while in jail, or that she has acted respectfully and courteously while unrestrained in court. Again, those don't exist in a vacuum either. There is a benefit to behaving courteously in custody. It will make your life better. There is a plus minus to how you behave in court in front of the judge that will ultimately sentence you. There is a benefit to all of this. It's not in a vacuum, which is actually what we saw argued in the Menendez case. In the Menendez case, we saw argument that the behavior in custody post the expiration of any further appeal was without benefit. There was nothing to gain. It was being done in a vacuum of what was being chosen to be done. The prosecution is kind of leaning towards this doesn't exist in a vacuum. There's a benefit here still. Defendant's impression management. It's like you've been watching some of our... Mr. Bloodworth, how did you enjoy the Sarah Boone trial, sir? Was it illuminating? Defendant's impression management while in a controlled environment does not mitigate the dangers associated with the court's finding that substantial evidence supports that she caused the death of her husband and the father of her children by poisoning for pecuniary gain. Presenting the court with a jailhouse certificate of achievement in faith-based parenting is ironic, not mitigating. Oh, he's not happy. Mr. Bloodworth. This is why the court is like, Mr. Bloodworth, I've read your papers. And he's like, touche. Presenting the court with a jailhouse certificate of achievement in faith-based parenting is ironic, not mitigating. Just the sass. The prosecution's not having any of it. They're like, look, yay for you, but no. Presenting a certificate of participation in seed starting and woody plants is beneath this proceeding. Oh, that really did piss off the court. Sir, gardening is never beneath the proceedings. I'm surprised you didn't argue, like, what plants is she studying, sir? I'd like to know. I'd really actually like to know, what herbs is she studying, sir? Because I have questions and concerns, given the circumstances. Let's see. The purported change in circumstance, therefore, is not material within the code. The legislature could have indicated that positive jail behavior is a change in circumstance, but decided not to. Accordingly, defendant's behavior while in jail does not provide her with the statutory authority to seek modification. Assuming arguendo that the defendant's assertion is legally viable, it is factually incomplete to the point of inaccurate. The defendant has behaved poorly while in jail, including inciting, indicating violence and danger? What? What has she done? OT. Yeah, all of you that are like, she's grown black-eyed peas. Tasted all right to me. The defendant has received 4. Now they're going to spill the tea. Look, now the tea. Now all the tea. The defendant has received 4 major disciplinary infractions, all of which have been upheld on appeal. The defendant feigned a medical episode for the sole purpose of manufacturing a complaint against jail staff. The defendant, in her walk the dog letter, docket 214, we'll link the video below, vowed to get those damn bitches, referring to Eric Richins' sisters. In May 2024, the defendant released an audio recording to the media declaring, quote, "This is war," that the defendant's assertion that she has a pattern of positive behavior in jail is indefensible when considering the totality of her jail behavior. I mean, he's not wrong. This, again, you guys, this is the prosecutor who's like, oh, You're going to open the door for me to talk about things? Mention it all. Mention it all. Mr. Bloodworth needs to be on Real Housewives. Like, can you imagine Bloodworth on the Real Housewives of Salt Lake City? He's like, receipts, screenshots. What's the other one? Damn it, I'm going to blank on the rest of the soliloquy from Heather. Receipts, screenshots, timeline, fucking everything. He's going to be like, receipts, walk the dog letter, jail call transcripts, fucking everything. He put in his motions that Kouri Richins called her attorney a dumb bitch multiple times. Why? Because he could. Why? Because he could. He's like, oh, you want to know what Kouri's saying in jail? Well, let me tell you. This is what she's saying in jail. You want to open the door to all of it? Yep. We're going to open the door to the nastiness, the rumors, all of it. All of it. We're going to talk about the husband, all of it. Oh, Your Honor. You want to know what she did? All the things up in custody, causing all the problems. Go read the walk the dog letter again. So considering her pattern of positive behavior, arguing a pattern of positive behavior is indefensible when considering the totality of her jail behavior. Well, I'm glad law nerds chat in the first person, fourth person, chat. Y'all are so wise. Y'all were like, no, let's see it. Let's see it. Where did they refer to her as parasitic? We need to know. We need to know. And now we get to know all of the tea. Chat, you are wise. You are wise. Look, remind me, if I ever say, let's skip a Bloodworth motion, be like, girl, you forget yourself. We are never skipping. It's like leg day. We're never skipping a Bloodworth motion. Ever. Ever. It's so ruled. Damn, that was loud. That's on me. I turned my headphones up. We're never skipping. We're never skipping a Bloodworth motion again. All right. The defendant asserts that this is a material change in circumstances, that her relationship with her sons is being irreparably damaged. The defendant does not relate this purported change in circumstances to either the court's finding that substantial evidence supports the murder charge or finding clear and convincing evidence that she poses a danger to the community. Accordingly, those findings remain unchallenged and undisturbed, and the pretrial order remains on those findings. And he makes the same argument. The legislature could have said that this was a factor. They didn't. Assuming arguendo, the defendant's assertion is viable. It is factually incomplete to the point of inaccurate. Certainly, this issue is complex, nuanced, and difficult. I appreciate that he acknowledges that, because it is. The 3rd District Juvenile Court has jurisdiction over this issue and is addressing it. The court, therefore, should defer as best it can to the factual findings regarding the issue to the 3rd District Juvenile Court. To the extent the court must address the issue, the defendant's own conduct has caused the damage to her relationships with her son, and then it is redacted. Lengthy delay is not a material change in circumstances. He is going to reiterate that the code could have considered it, and they did not. And he says it does not change the court's ruling. Assuming arguendo that the defendant's assertion is legally viable, the defendant asserts it in a passive voice. Oh, Mr. Bloodworth, you're such a nerd. We love it. The defendant asserts it in the passive voice. Mr. Bloodworth is better than Grammarly at this point. At the time of the original detention hearing in June 2023, it was believed that a preliminary hearing and trial were imminent. This is not true. Oh, Mr. Bloodworth. At that time, defense counsel had reviewed little discovery, and the defendant declined to set a preliminary hearing date. The defendant did not ask to schedule the preliminary hearing until 256 days and 4 scheduling conferences following the detention hearing. Oh, those are facts you can't get around. I was wondering why there was no preliminary hearing on schedule in the case. It was wild. 256 days. The defendant then scheduled the preliminary hearing for 84 days in the future, in part to take advantage of new legislation governing preliminary hearings. Oh, really? The defendant has never proposed a trial date earlier than April 28th, 2025. I know, I swear, you guys, if they move Karen Reed's trial to overlap with this trial, I don't know what we're going to do. A new release plan is not a material change in circumstances. Defendant asserts that a new release plan is a material change in circumstances. The defendant does not relate this purported change in circumstances to either the court's finding that substantial evidence supports the aggravated murder charge or a finding of clear and convincing evidence. Regardless, the legislature could have considered it and didn't. Assuming arguendo, the defendant's assertion is legally viable, it is factually inaccurate. The defendant asserts that living with her brother, quote, the brother that she was on all the jail calls with. I did do a somewhat might be underselling, a somewhat snarky jail reading, or a somewhat snarky reading of the jail calls between Kouri and her brother. That's on the playlist too. We've covered this case for a while. Defendant asserts that living with her brother will remove the risk of inadvertent interactions with possible witnesses in the case. The rub, however, Mr. Bloodworth. The rub, however, is that her brother is a material witness in the case. Facts. The same brother who the defendant in her walk the dog letter asked to testify to a narrative that is contrary to all the evidence in the case, to include the defendant's own statements. The brother was the one in the walk the dog letter that she was saying, Sky needs us too. Like, my defense attorney needs us to connect these things. Can you say this? Did it border on witness tampering? I think so. Did they ever charge it? No. This is the same brother who claimed on national television that the defendant and Eric Richins' marriage was, quote, probably in one of the best spots I've ever seen them in quite some time, even though she had recently consulted with a divorce attorney and planned an immediate future with her longstanding paramour. And dude. For those of you that didn't watch the preliminary hearing, you're welcome for what you're going to do this weekend. But in the preliminary hearing, there was a text message with her paramour that said, and I am paraphrasing, but essentially, it's going to get better for us, her and the boyfriend. Just wait till Friday. Guess when Eric died? It came out in the preliminary hearing, and I was like, oh, definition of gagged. This is the brother that went on national TV to say that the marriage was probably in one of the best spots I've ever seen them in for quite some time, even though she had recently consulted with a divorce attorney, had attempted to kill him on Valentine's Day, and then went and spent the day with her boyfriend, and planned an immediate future with her longstanding boyfriend. Redacted. What is redacted? Damn it. The defendant and her brother have demonstrated they will work together to do anything to see that she is not held accountable for causing Eric's death. The motion disregards Utah law and factual accuracy. Ouch. 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 Not only is the law not on your side, you're wrong. The defendant's asserted changes in circumstance are not material under the law. According, the court should deny the motion as a matter of law, assuming arguendo that the defendant's asserted changes in circumstances are material, they are not factually supported, and cannot be. Accordingly, the court should deny the motion as a matter of fact. Is the parasitic language redacted? Is it a quote from somebody else? Damn it. Oh, I'm going to have to Control F myself. Hold on. Well, Command F. Where is our... It's not in there. Am I spelling parasitic wrong? No. Maybe. Chat, help. Am I spelling wrong? No, I'm not. I've Controlled F'd myself. I've Command F'd myself, but I am not finding parasitic. Yep, I did spell it right. Thank you, chat. You guys are the best. It's in the redacted bit? Motherfucker. I am so mad. It's in the redacted bit. It's in the redacted bit. Well, God damn it. So, it's in the redacted bit. I wonder if the parasitic language, because the defense said whether the prosecutor called her parasitic because she was a woman or whatever. I wonder if it's attributed to something someone else said. So, somebody said in the chat that counsel spelled parasitic wrong, or I mean, that Bloodworth would never. Let's see. I mean, no, we're not even close. We've got Paramore and irreparably and Park City. Like, we're not even close. And I imagine if Bloodworth is saying it, he's saying it with his whole chest. So, yeah, Bloodworth is. Boo. No, it's not in there. And it wasn't in the defense reply. It only came out in court. Damn it. I mean, it was a very, very, very spicy motion. I tried parasite and parasitic. I'll try it again. But it would have come up under the PARA. Yeah. I tried para. I tried PE. It's not under there. It's got to be redacted. And if it's redacted, I wonder if it is a, I wonder if it's something attributable to somebody else. So, Huma said, so grandstanding by the defense for the camera. The defense, to be fair to the defense, probably wouldn't look at the redacted version for the public vis-a-vis the version they have. So no, I think it was something that made them mad. So I imagine the defense was just mad. But I tried all the versions that I could think of, and we read the whole thing. Utah's not an easy jurisdiction to get court documents out of, but we read the whole thing. I really don't think it's in there. We have control F'd our way into oblivion here, and I think it's probably in the redacted language. And if it's in the redacted bit, I wonder if it's attributable to someone else's comment. But it sucks. But I bet you it's in the redacted bit. So, which means it's not really the prosecution name calling. That's not really, name calling isn't really Bloodworth's way, is it? It's a more nuanced and intellectual shade. So I wonder if it is, I wonder if it's someone else's statement. So let's see. Laura says it's in the motion to sever. It is? Well, I'll go Command F the motion to sever. I mean, now we need to know. Let's be optimistic. I'll go pull the response to that because I actually have all of them. Let's see. If it's in the response to the motion to sever, let's look at the state's opposition. I presumed it was here because, well, this is what they were talking about when it came up. But let's see. Let's Command F this motion. We're not going to go through the whole thing. Emily, didn't you say? Oh, yeah, it is. It's right in there. Oh, thank you. It's right. Laura, it's right fucking there. Thank you. The law nerds, just applause for Laura at this point. Just, where is it? Thanks, Laura. 10 out of 10. 10 out of 10. Oh, I keep messing with my in-ears. I need to stop. All right, 10 out of 10. Why? Because I'm sick in my brain. Like, sick plus ADHD is the worst of all of the possibilities because my brain literally can't do anything. All right. State's opposition to defense motion to sever. We just need a swoop. We need a timestamp for all of this. State's opposition to defendant's motion to sever. This goes back to me saying, never miss a Bloodworth motion. The state has joined all 9 offenses in a single information because they are directly connected to the defendant's motive for financial gain and for the world to view her as an accomplished person of status. The offenses that the defendant seeks to sever precipitated other offenses and an arc of the defendant's increasingly aggressive parasitic behavior connects all 9 offenses. Moreover, the aggravated murder and the attempted aggravated murder are part of a common scheme or plan. The defendant is not prejudiced by keeping the offenses joined because all the evidence involved is admissible in separate trials for non-character purposes, motive, plan, etc. Well, whoop, there it is. The increasingly aggressive parasitic behavior. So it's it's mortgage fraud and then forgery and then insurance fraud. So, I mean, it's not wrong. I mean, is he wrong? Chat? Is he wrong? Is he wrong? Tell me, is Bloodworth wrong? Well, you all saw the preliminary hearing. Is he calling the defendant's name? Or is he referring to all of the fraud? I mean, I can see why the defense is mad. It's like, get off my client. But also, we know this is a spicy prosecutor, so I'm not surprised. He's spicy. But it was the behavior. He was not calling her a parasite. But he did say it was parasitic behavior. However, she was forging financial documents to take out money from the home that was not hers. She was forging bank records to get additional mortgages to make it seem that her husband's business finances were her own. No, not wrong. Let me see if the defense responded to that motion. No, just in court. So I guess that was the defense's opportunity to be like, it's so unfair. So we know that the court ruled that the financial cases will come out, the mortgage fraud will come out, but the behavior of some of it will come in for motive because it's pecuniary gain. So some of that will come in, and the life insurance will come in. I'm not wrong with the judge. So some of it will come in as motive. Yep. But the court will have to go to how far it will be allowed to come in. I think the court will allow some of it for motive to show the state of her businesses, right? Because the court's going to allow them to show that her business was over leveraged. They're going to allow the prosecution to show that she knew that the only way she would take any financial gain out of the marriage is if he died while they were married. So why that part matters is because of how over leveraged her businesses are. So it'll narrow it down to her businesses being over leveraged. I don't know if they're going to be allowed to show that some of that was done by forgery or fraud. And I don't know if it matters. So I think we will just see the over leveraging, and then we will see the forgery as to the life insurance, which I think is more damning. So I don't know how much it helps, but it'll streamline the case. Getting sidetracked into an entire financial case, I thought the financial expert in this case was great. I thought they were fascinating. I thought they laid it all out clearly. But a lot of that financial evidence of how she was over leveraged will still come in, just not that she was forging documents and using his business to forge documents to the bank. That won't come in. I think the insurance fraud is more damning and more close in time. With that, I think we should get to questions. Now we found where the parasitic came from. 10 out of 10, Laura, thank you. And let us wrap up. Let us get to questions. I can tell that I am running out of steam. Have you seen it? It's just like, I know that I'm still not feeling well. And I'm like, oh, we've been streaming for almost 4 hours. And I'm like, my brain is done. Is done. So I saw an answer in the chat that I was going to pull up. I didn't see the original question. Apologies, but Cheryl Ray was saying that I have Pacer. I do use Pacer, but states have their own systems. Yes, some of them are very hard to access, and most states have documents available online that the public can access. Some states charge you quite a bit of money and there are a lot of hoops to jump through. Some states you have to be within the state to go grab them, like Massachusetts. They are not available just online, but people grab them in Massachusetts and post them in line for the most part in the Karen Reed case. Florida is free. Florida is great with that. Florida's system for finding documents is quite easy. Utah is a little bit more challenging. California is quite expensive. Nevada is quite expensive. So it really just depends. And then PACER is the federal system and has quite a lot of the federal courts and appellate courts and stuff linked. PACER needs an account. Court Listener, as folks have pointed out, Court Listener is free for federal cases. It's donation based. It doesn't do state cases, etc. So Shell said he does it for the strong words, severe, extreme. He does. The court definitely has a cadence of how he talks. Christy said, hope you feel better. It's fall. I thought I was in the clear when my kids were both sick, and I was not. I got overly optimistic. That's okay. I laid in bed and played. Yesterday, it was just a full, like, I am done for the day. My brain is tired. But I got to play some of my mobile games, the Pokemon Sleep, the Midas Merge, and more. So we got to do all that yesterday. We're going to get to some questions, and then I'm going to scoot. Let's see. Envy Dembinski, 14 months of being a law nerd. Glad to be a member. Glad to have you here as a member. A lot of you saw me talking about our membership in the chat yesterday during the premiere for the podcast. I pulled up our chat behind the scenes, a little behind the scenes. I don't know if I'm NDA'd on this. I don't think I am. It's going to be fine. I did a talk with growing YouTube creators that YouTube hosted about channel memberships, about building community, and about creation in that way. And a lot of people didn't know about premieres because they're like, well, if I don't live stream, can I still access some of the things that I love about channel memberships? And I said, yes, you can premiere a video. I have a video premiering now. Let me show you. And so I went and showed our chat in the talk that I was giving with YouTube and YouTubers. And it was really fun to get to see all of you guys there in the chat and give some memberships and show everybody how it worked. It was 10 out of 10. I loved it. But I didn't get to answer all of the questions in the chat because I was in the talk. Anna Fox said, bit sick, but so ready for court. I was ready for court too. I'm sad we don't have the whole hearing one of these days. Bryce Jones says, I know you've been asked this, but do you still practice? And what did you practice? Also, I live in Utah and drive by that house that Kouri bought all the time. Bryce, that's got to be wild seeing that house. I was a criminal prosecutor for over 10 years. Then I did consulting work. I also was a civil research attorney for civil judges. I also worked in law school at the U.S. Attorney's Office. Do I still practice? Very rarely these days. Am I still eligible to practice? Yes. I do more consulting. I don't do in-court work because I'm in court with you guys. So yes, I still do some consulting. Yes, my license is still active because you never know. You never know when you might need to. So yes and no. But no, I don't take a lot of clients because if court popped off and I had client work, I would be angry, to be honest. And clients don't deserve that. And when I'm covering this many cases, it would be really hard to run my own because I love doing this. I love doing this. And so if I can do this, I have done the court enough. I love being here. So this is my happy place. Let's see. Dr. Pepper and chocolate, EDB mods and law nerds. We'll get back to a dirty soda conversation. It's a thing. But Sonic now has dirty sodas that you can order, but it's not uncommon, depending on what area of the country that you live in, to have a dirty soda like a Dr. Pepper with cream and flavoring and stuff. Britt Bottoms, love me some EDB on a Thursday. Good to see you. Soon to be Tuesday, Wednesday, Thursday. Excited. Hi from Cali. PSL until they take it away from me. Me too. That's me with my pumpkin cream cold brews. Michelle said Zoom jury selection sounds odd. It feels weird to me, but if that's what they do. Pumpkin and Spice's mom says, I'll put this in a safe place, opens a portal. It really does. It's like, if I put this here, I'll never forget where it is. So with the dirty sodas, it's so funny. Valkyrie Arts said exactly what the argument was. I was talking to Judge Abby about dirty sodas when she was out here in Tennessee. And I was like, I can't wrap my head around it. I love a root beer float. Like, I love a root beer float. And that was her argument. She's like, it's basically a root beer float, but not frozen cream. And I was like, oh, I need to try that. And I did. And I enjoy the ones at Sonic, but also I prefer, I don't know, I don't prefer the cream in my soda. Like, it's a coconut cream. The ones at Sonic in the Dr. Pepper, not my favorite. I prefer like a flavoring, like a Coke with like lemon flavoring, or even lemon, or a Dr. Pepper with lime. I like the citrus in the sodas. But yes, there was a huge soda culture in Utah, and it became like a central feature of, well, it's TikTok, but also of the Secret Lives of Mormon Wives, which was about TikTokers. So it's come into broader awareness. But it's just like all the giant cookies that came from Utah too. The sugar culture is real. Whiskey has less sugar. Sorry, Utah. But I'll take my whiskey. Y'all take your dirty sodas, and it's all fine. Lime Coke is so good. Citrus and Coke is so good. Rhea Sun said, Emily, gingerbread oat chai latte. Sounds very good. I love a chai. Gingerbread chai. I love a dirty chai. Put some espresso in it. Oh, so good. Heather G said, Fanta Orange Dirty is where it's at from Sonic. I will try that. That sounds amazing. Like, that sounds amazing. That sounds really good. So anyway, let's continue. Molly Cole said, Emily, where can we watch Judge Abby? Can we watch Judge Abby anywhere? No. Judge Abby is in a jurisdiction that does not do televised court. So no, we cannot. Judge Abby would say, good. That is good. But no, it would be nice to watch Judge Abby, but no. Let's see. Jess says, me when I lose something, it's definitely in a safe place. Jess, exactly. There was stuff I found when we moved the last time. I hate moving. I love like being settled. I don't mind going somewhere new. I hate the process of moving, but the stuff I found, I was like, this was lost forever. It disappeared. I'm like, I swear it was hidden from me and then replaced just so I would feel like I'm losing my mind. Kate's History Mystery says the Kates are tuning in from Liverpool. Good to see you. Did everyone get their red cups today? I've not been out of my house today and probably won't, but is it red cup day at Starbucks? Yay. Kel said, happy Thursday, Law Nerds. Thank you, Kel. Tempted to go to this trial, only an hour away. It will probably be pretty interesting, and I would pick opening, closing, and go early. What I have noticed for anyone interested in watching trials, here's what I've noticed about public trials. They are always empty at the beginning. Opening statements in the first few days, once the prosecution rests, seems to be when public interest picks up. So we saw that in Det v. Heard. The first week or two of Det v. Heard, the courtroom was fairly empty. It was like Chanley Painter and 3 other reporters. As the plaintiff rested, then it started to get into just busy days. But generally for opening statements in the early days, it's much easier to get a spot, unless it is one of the really intensely locally attended cases. What I did notice from this court is this courtroom looked pretty full for this last hearing. I think that's a lot of family, but this courtroom looked pretty full, and the courtrooms are pretty full. So It's Always Sunny said, Emily, I wanted to give you some law tea. I work as a lit assistant until yesterday, and the firm is reporting a judge because she cursed me out on the phone. Oh, judges should never. I'm sorry. It's Always Sunny. The firm should report the judge. That is completely inappropriate. The judges should never. Kate Gibson said, excuse me, stewardess, Octo took my peanuts. Octo, stop stealing nuts from the law nerds. Stop stealing nuts from the law nerds. Don't worry. We will give you some Biscoffs and whiskey to make up for it, unless you don't drink whiskey, and then we will give you Biscoffs and whatever you would like. A dirty soda to make up for it. Let's see. Laura said there are Kouri texts in the motions to sever. In the response or the motion to sever? Laura, just reply to your super chat and I'll go look for it. But I do have to remind you guys, because the Law Nerd Shop 2.0 is loading. First, if you have the Law Nerd app, make sure you have the Law Nerd app. If you don't have the Law Nerd app, make sure you get the Laundered app at launderedapp.com. But if you just want to stay in the loop with what's going on, that's the wrong screen, Emily. Hold on. If you want to stay in this loop with what's going on in the Laundered shop, you can also visit our new Laundered shop at launderedshop.com, check out vibes, and sign up to be of the first alerted when the new shop launches and when the new products are available. So the new Laundered shop, you are welcome to hop on the list if you would like. You will also be notified in the app, both. If you want to do all the things, this counts as all the things. So launderedshop.com, Laundered Shop 2.0 is loading. So don't forget to check it out. Octo, you are welcome. Octo's like, tell everyone they can check it out. I will. App, email, your choice. If the app is not for you and you want to know, then this is the way to do it. You got the chat. You guys know the facts, so go and break it. We break everything. The company we are working with, as we relaunch the shop that is still on Shopify, has load balanced it. It shouldn't break, but occasionally that does happen. That's why I wait till the end of stream, because you guys are the ride or die law nerds. We need you to know first. You guys are like, we're in it. We're in it. So, app and Laundered shop, and we're going to do a few more super chats, and then we're going to go. Oh, wait. I wanted to go look and see. I wanted to go look at the reply and see if it is in the, where did it go? It absolutely disappeared. I wanted to go look at the Kouri text in the motion to sever. Are they in the motion? Or are they in the response? Let's pull up the response first, and I'll zoom through real quick. Let's see. This is the state's op. And let me see if those are in here. I wonder if they are easy to find. Oh, yes, they are. Oh, in the response. All right. Emily said, never miss a Bloodworth motion. And here we go. Laura, thank you. Let me go take a look at that real quick. And then I'm going to have to wrap up because I do not feel great. But the chat wants the tea at this point. So we might have to go through this whole motion. Maybe I'll do it on Quick Bits too if I find anything else. So if I find anything else, I'll put it on Quick Bits. But the prosecution is arguing that all of the offenses are connected together. Let's swoop. We were in Q&A and now we're not. All 9 offenses are connected together in their commission. To understand how all the offenses are connected together in their commission, the court must first understand the defendant. Kouri Richins is a woman aggrieved by her own perception regarding her place in society. Wow. We're gonna do this whole motion a different day. We're gonna have to. No, I'll go through it and highlight it in Quick Bits. Aggrieved by her own perception regarding her place in society. I'm waiting for him to say Kouri Richins is a defendant and intellect has been chasing her, but she has always been faster. Like, I'm the shade. Shortly before the aggravated murder, the defendant expressed this grievance in a text message to her longtime lover, Josh Grossman. Oh, the paramour has been named. For those of you in the chat saying Bloodworth enjoys writing these, oh, you bet he does. Oh, you bet he does. When I was little, I grew up scrubbing other people's toilets in Park City at, quote, rich people's houses. Ma'am, you were Googling luxury prisons for rich people. When I was little, I grew up scrubbing other people's toilets in Park City at, quote, rich people's houses after school. Christmas breaks all summer, I worked for my aunt's company. I was just always looked down upon because you're literally the person cleaning toilets. I always said to myself and my aunt, one day I'll own properties in Park City like all these rich, snooty people, and I will never be like them. Tomorrow, I close on 3 properties all in the same day, 2 being in Park City. That's a huge deal to me. Biggest accomplished to date career-wise. It's never been about the money. It's about being able to say, I too can have properties in PC, and him putting in every single spelling is just something. And he's like, Bloodworth is like, actually, ma'am, it's YOU''RE. It's not the right but okay. I too can have properties in Park City, and you're not better than anyone. The way you treat people, and I can prove it. Tomorrow is a really big deal for me accomplishment wise. Well, the defendant wants others to view her. Oh, this goes back to the impression management. The defendant wants others to view her as an accomplished person of status. This defendant projected an image of ostensible brain, an image of ostensible accomplishment and status to business associates, friends, and family, falsely touting that she acquired $14 million in real estate in 5 years, profited $1 million from 5 projects, and employed 147 people based out of Park City. The defendant paid for vacations with friends and doled out cash to family members. She purchased home. The mortgage fraud is frauding. Allegedly, she purchased a home for her best friend and carried the mortgage. She did what? There was so much more tea. She purchased a home for her best friend and carried the mortgage. The defendant's accomplishment and status, however, were an elaborate facade. The defendant created and perpetrated the facade by parasitically. Oh, it's in there again. They're not done. By parasitically appropriating Eric Richins' financial records. The defendant extracted Eric Richins' premarital home equity, which was not hers, premarital home equity and available credit. She fraudulently traded on his company's liquidity to borrow for her business and relied on his company's liquidity to salvage her Oakley project. In reality, the defendant was insolvent when she sent her paramour the text message on November 29th, 2021. When the defendant closed on 3 properties on November 30th, 2021, she added $1.1 million of high interest debt to her already staggering and unserviceable debt load. By that day, she had already defaulted on 1 loan and was delinquent on several others. One of the defendant's lenders sued her on December 9th, 2021. Contemporaneously, the defendant continued efforts to borrow from new high-interest lenders to meet her existing obligations. On December 23rd, the defendant contracted to purchase the unfinished Midway mansion using $2.9 million in high-interest debt, even though she lacked the financial ability to service the additional debt or rehabilitate the property. By the end of 2021, defendant stood on the precipice of total financial collapse and exposure of her accomplishment and status facade. To protect and perpetuate her facade, the defendant needed Eric Richins' $5 million estate and $1.35 million from his life insurance proceeds. The defendant needed to cause Eric Richins' death. The defendant would not have fraudulently applied for a new policy to ensure Richins' life, contracted to purchase the unfinished Midway mansion, and plan a new future with the paramour at the Midway mansion unless she also planned to cause Eric Richins' death. The mortgage fraud and related forgeries precipitated the insurance fraud and related forgeries, the attempted aggravated murder, and the attempted murder. The defendant needed Eric Richins' estate and life insurance proceeds to satisfy her creditors. I can see the argument, though, that she thought she would dig herself out of it and that it didn't come to pass until January that she realized she couldn't dig herself out of it. So when the frauds were perpetrated, the intention was like, I'll get even again. And I'll get even again. So I don't know if when the mortgage fraud was perpetrated, she thought this would be the end result. I think she thought she would get on top of it. So let's see if there's any other. We'll go through the rest of this motion. I'll summarize the spicy bits in quick bits. I'm going to answer a few more questions, but thank you for pointing out the spicy bits. I will, more tea. We'll go through more tea in quick bits because I want to answer a few questions and then we will, yep. Different day. We will. Different day. Erica said, happy 3-year anniversary, Emily. Weird not having a red gavel. I know. Congratulations. When the colors change, I'm actually asking them to change the colors on the gavels more frequently. I think that would be really fun. Katie said, got my fabulous laundered cups today in purple boxes. Aren't they fun? Bloodworth voice with Mr. Burns' hands. Mr. Bloodworth. Tina KS Launer, good to see you. Chad is bae. Mods are the best. EDB keeps me entertained. Good. FYI, woody plants are trees, shrubs. Shrubbery. A shrubbery. Most vines and ground covers. Yes, you pronounced it correctly. Whoop, whoop. I don't know if I could do it again. Annuals and perennials. Perfect. We've learned all the things. Lawnards. I am going to go rest. It was wonderful to be in court with you today. I will continue to go through this case and try to find the rest of the hearing. Tori says, what does sick mean? It means spelling in original. I don't know what the C actually stands for, but it's not, it's like, we didn't typo this. This is literally the spelling in original. I'm sure someone knows what the C stands for. I don't know. So I am going to go rest. Lawnards, I am going to be recording quick bits. It might be a bit late, but I will let you know. We will do a behind the scenes of one of the podcasts this week when I get to recording them. I don't know when that will be. I am going to go rest. Spelled incorrectly. Thank you, Becky. I didn't know. I could never remember what the C was for. Spelled incorrect. Perfect. Thank you. The incorrect spelling. I love that though Bloodworth is like, well, she thinks she's all that and a bag of Doritos, but no. Ooh, Doritos sound good. But no, it means it's quoted exactly in the spellings in the original. He's like, actually, it's the wrong your. The wrong your. Goosebump. I don't know if it's a Latin word. No, it's, wait, all of you are saying it's a Latin word. Latin, so thus. Then why do we use it for spelling in original? All right, I'm going to be more confused. Law nerds, I will let you nerd on figuring out the origins of sick. I like spelled incorrectly. I'm going to go with the law. I'm going to go with the law nerd definition, but I'm fascinated to learn the Latin word because the more you know, like it was written thus. That makes perfect sense to me. The law nerds know so much. This chat is bae. Look, if there is a place to appreciate the nerdy sass of Bloodworth, there is no better chat on the internet to appreciate the nerdiness and also look at Bloodworth and be like, sir, can you just, well, actually a few times in this, like just give us all life. With that, law nerds, don't forget to get the Law Nerd app, lawnerdapp.com. Law Nerd Shop 2.0 is loading if you want to sign up for notifications there. I will be back with you when? Monday. What's today? Thursday? Monday. I'll be back with you Monday. I'm going to go rest. We will have a new podcast for you. If you haven't checked out this week's podcast, go check it out. I cover this case. I cover Karen Reed, and we cover a bit of Diddy. I will see what else is going on in the law. If you are not tuned in for the Quick Bits on Monday and are wondering, Emily, where are you covering some of this stuff? Quick Bits has started supplementing in the cases that we are keeping track of shorter. So that Monday episode, either on the Quick Bits channel or your audio. But the outro is going to tell you all of that. So I'm going to roll that and I'm going to go to bed. Bye, Law Nerds.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.